How is everyone? Good. Have any of you seen or heard or learned anything about this case or the people and places involved in this case? No media inundation or anything like that? All right. I would just let you know, I think someone expressed a concern. The media is present, but we have an agreement with local media not to film jurors or publish their names. So if any of you were concerned about that, that's generally how news is reported. I don't know if you've kind of noticed that in the past in watching other cases, but that's our agreement with the media, so you shouldn't be concerned about that. All right, state can call your next witness.
City Corporal Michael Gabo.
Raise your right hand, please. Do you solemnly swear or affirm that the testimony that you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Can you come this way?
Good morning. If you would please introduce yourself and spell your name for us.
My name is Corporal Michael Gabo. Last name is spelled G-A-B-O-T.
Thank you.
And Corporal, how are you employed?
I'm employed with the Hillsborough County Sheriff's Office.
And how long have you been working with the Hillsborough County Sheriff's Office?
A little bit more than 14 years.
And your current position is what?
I'm a supervisor in District 4, which is our southern Hillsborough County area.
All right. Back in August of 2022, what was your position at that time?
I was a detective assigned to the HCSO homicide unit.
All right. And at that time, about how long had you been working with the homicide unit?
I believe at that point I'd been working with the homicide unit approximately 4 months.
Right. And now you're a corporal. Is that considered a promotion within the sheriff's office?
It is.
Okay. Now, as a homicide detective, what were your general duties at that time?
May I explain?
Sure.
So homicide detectives assigned to the homicide unit at the time that I was there had various duties. Those included death investigations of natural deaths, suicides, overdoses, homicides, kidnappings, and other violent crimes. Homicide lead investigators, those were people that were assigned to investigate actual murder investigations or homicides of any kind. There are typically 3 roles in those sort of incidents. There's a lead investigator who's assigned by a supervisor to oversee an investigation. Their job is to draft affidavits, oversee and summarize the investigation for the attorneys, provide presentations, and conduct most of the interviews. There's an assistant detective whose job is to assist the lead detective. They're supposed to know as much of the case as they can in case something happens to the lead detective. They're incapacitated or unavailable. And then there's typically going to be a crime scene detective. The crime scene detective's role is to manage crime scenes for these types of incidents. So maybe there's 2 crime scenes. There may be 2 crime scene detectives. Any other roles outside of those are going to be ancillary duties assigned at various people within the division.
All right. Now, in the death of Jaylah Bass, were you given any particular assignment?
I was assigned as the lead detective.
All right. When did you first receive the call about the shooting?
I believe I received the call on August 29th, 2022, sometime during the late evening.
All right. And what did you do upon receiving that call?
I ultimately responded to the area of the incident scene.
All right. Were you provided on your way there any information regarding the call or regarding anything like that?
In my initial receipt of the information for the call, regarding my response, I was informed that the shooting involved potentially an accidental shooting where 2 children were shot at a residence within our District 1 area, which is in the north part of Hillsborough County.
All right. Were you able to hear the 911 call?
I was.
All right. And did you hear that before you went to the scene or on your way to the scene?
I reviewed a 911 call as I responded to the scene, so prior to my arrival.
All right. What did you do when you got to the scene?
When I got to the scene, I met with my supervisor at the time, which was Corporal Florio, now Sergeant Florio, other detectives, and the deputies on scene, and I ultimately reviewed some body-worn camera.
All right. And do you recall whose body-worn camera you reviewed at the time?
Deputy Scott Rainey.
All right. Did you go into the apartment at that time?
I did not.
All right. What did you do next?
After reviewing the body-worn camera and receiving my assignment as a lead investigator, I responded to Tampa General Hospital.
And why did you go out to Tampa General Hospital?
I was informed that Jaylah Bass was the...
Objective to abstain.
Without telling us what you were informed, what was your purpose in going to the hospital versus staying at the scene?
I responded to the hospital to check on the victims.
Okay. When you got there, were you able to check on the victims?
I was.
All right. Who else were both victims there, or were they in separate hospitals?
Both victims were in the same hospital in separate rooms.
Okay. By the time you arrived there, was Jaylah Bass pronounced deceased?
She was.
Okay. Was Jermaine Bass, the son, was he still alive at that point, obviously?
He was.
Okay. And what was his condition when you got there?
He was incapacitated in a hospital room.
Okay. Was he awake, coherent, anything like that?
He was not awake. He was alive. I could see an obvious wound to his head, but he was unresponsive.
All right. Did you see anyone else there while you were there?
Yes, I interviewed the mother of the children, Shirley Bass, in the presence of her sister.
And how was she? What was her demeanor at that time?
She was, she had just been informed at the time that her child was deceased, that Jaylah Bass was deceased, and she was very difficult. She was very difficult to interview. She was crying. She was in the process of what I determined to be grieving at that time.
All right. So what did you do next?
What did I do next from the
From
hospital?
the hospital, did you, yeah, after the hospital, where did you go?
I responded back to the area of the incident scene.
Okay. And what did you do when you got back there?
At that point, there was a search warrant that had been authored for the residence. Detectives and crime scene investigators and other personnel from HCSO were inside of the residence. So I entered into the residence, met with personnel inside of there, received a brief walkthrough, and assisted with a search of a bedroom.
All right. And the search of which bedroom did you assist with?
It was the bedroom that was identified as belonging to the parents.
Now, the jurors by this point have now seen plenty of pictures of the residence and know, so they're familiar with the room you're discussing. Can you tell us what you did as far as assisting in the search of that particular room?
Primarily, I assisted with a search of the closet.
Okay. Were you there when the dresser drawer was searched, the silver dresser?
I was in the room when it was searched.
All right. And were you there when the firearm was recovered?
I was.
All right. And did you see them remove the firearm from the actual dresser?
I did.
When the firearm was removed, were you able to observe whether or not it was loaded with any bullets?
It was not loaded.
All right. Was the magazine within the firearm at the time that it was removed from the dresser?
I believe it was separate from the firearm. I don't recall specifically.
Were there any other live rounds within that magazine?
There were not.
What type of firearm was this?
It was a Glock 42 firearm.
And what type of bullets does the Glock 42 take?
It fires .380 auto caliber ammunition.
Is this a common type of firearm?
Relatively common, yes.
What type of firearm is issued for the sheriff's office?
The sheriff's office has issued Glock 45 as the primary duty weapon, which fires 9mm.
Which one is a stronger caliber, or does it matter?
Relevance?
Overruled.
So the 9mm and the .380 caliber use the similar size projectile. It's approximately a .357, but the 9mm has a larger case with more powder in it, and therefore it's a higher charge version of a .380.
Now, after searching the home, did you have what was your next involvement with the investigation?
I responded to the District 1 office where the defendant was.
Okay. Did you obtain a phone while you were at the residence?
I was informed that personnel at the scene, conducting the crime scene, handling a documentation and capture of evidence, did recover a phone.
Okay. Were you able to determine what the phone number was for that phone?
Yes, I was.
All right. And after obtaining that number, did you do anything with that information?
Yes. Detective Vertu, who was my assistant detective, completed an initial request for call detail records with the phone company, which was T-Mobile. And then later, ultimately, I completed a search warrant for a more detailed information related to that phone number.
All right. Did you ever receive a return of those call detail records?
I did.
All right. I'm showing you what's been marked as State's Exhibit number 29 and ask you if you can look at that. Do you recognize those?
I do.
And are those, in fact, the call detail records you received as a result of your subpoena?
They are. Or it was from the search
Or
warrant.
from the search warrant? Judge, at this time, I would move to have State's Exhibit number 29 admitted into evidence.
Objection.
Will be received.
All right. And do these phone records give you or indicate who the owner of the phone number is?
They do.
All right. And in this particular case, where it says subscriber name Jermaine Bass, is that in fact who the owner of that phone number is, based on their records?
Yes, it is.
All right. And the phone number we're discussing, is that it right there, 813-696-7195?
It is.
All right. What does the call detail record give you? What information does it tell you?
So a call detail record is a record provided by the phone company which, because a phone company requires a lot of information to provide that customer service, when they have a connected phone, that phone oftentimes connects to a tower to complete the service call or the internet connection that's required to provide the service that the customer requests. So some of the information that's captured in a call detail record may be location data, it may be numbers called, whether that call was incoming or outgoing, the duration of the call, what type of call it was. For example, an SMS may be considered a part of a call detail record or a text message. An MMS or a picture message may be part of a call detail record, or an actual voice call may be a portion of a call detail record.
All right. So it will give you indications of when phone calls are being made from that phone as well as when they're being received?
Correct.
All right. And on when you get these records, on what timeline are they set?
They're set on UTC, which is a universal time that's consistent across all time zones.
Okay. So what is our time in relation to UTC time, the Eastern Standard Time?
Depending on the time of year, we're either on Eastern Daylight Time or Eastern Standard Time. At the time of this incident, we were 4 hours behind UTC.
Okay. So the times that are printed out on this call detail record are 4 hours ahead of what our actual time is. Is that accurate?
That's correct.
Okay. Now I'm going to direct your attention. Before I do that, Corporal, do you recall when the 911 call was received regarding this incident?
It was received on 8/29/2022 at 10:33 p.m.
10:33 p.m. Okay. Now I'd like to direct your attention to the very last line on this particular form. It indicates an outgoing call on August 30th of 2022 at 02:34:58. What time is that? Would that time be here in Tampa at that moment?
That would have been 8/29/2022 at 10:34 p.m. with 58 seconds.
So that would have been approximately 1 to 2 minutes after the 911 call was made in this case.
Objection meeting.
Sustained.
How long after the 911 call would that have been?
Sometime between 1 and 2 minutes after the initial 911 call.
All right. And what is that call, if you can tell the jury?
That is an outgoing call to phone number 813-516-3376.
All right. And that is an outgoing call, meaning someone made that call from that phone at that time.
That's correct.
Now, can you tell whether or not that phone was answered?
From the duration of the call being 5 seconds, even though the call says it's completed successfully, in my experience as an investigator, that typically means the call was not answered and it went to voicemail.
Okay. Were you able to determine who that phone number was that he was calling?
I was.
And whose number was that?
It was LaQuanza Thomas, who is Jermaine Bass, the defendant's mother.
Did you ever receive any video from the location?
Yes, there was video surveillance recorded from a residence that was sort of across the street from where the incident occurs. A residence, I believe, is 13937 Heritage Club Drive.
All right. And did your office, did the sheriff's office obtain that video, that surveillance video?
They did.
And did you notice anything of interest on those videos?
Yes, I did.
What did you see?
There's vehicles that are seen coming and leaving and then returning to the area of the incident scene prior to the 911 call being received, and those two vehicles are going to be determined to be Shirley Bass's vehicles. She owned both of them.
Okay. Okay, so you were, what two vehicles did she own?
She owned a Mercedes C300 and a Nissan Titan pickup. Both of them were white.
Sorry, Corporal, I got the wrong. And does this video show where those two vehicles were parked?
It does.
Okay. And you're able to see, and were you able to determine whether the time was accurate on the videos?
Through the other detectives, yes, I was.
Okay. And did you in fact learn that it was a minute behind?
Yes.
Sorry, I got the wrong record. All right, so I've now put in State's Exhibit number 6, which has already been admitted into evidence. And I'm going to go through some of these with you, some of these videos. So I'm going to start with The first video, that is an MP4 file dated 9/1/2022 at 8:07 a.m. Now, if you could, I'm going to pause this real quick. I'm happy to do this. If you could, Corporal, could you stand and show the jury so that they can see where the cars, the vehicles you are referring to are located, and if you could describe it so it's clear for the record.
They're going to be to the top right of the screen, and the white vehicle, the white pickup truck here is going to be Jermaine Bass's Nissan Titan, and the vehicle just to the left, or to the right of it, from the perspective of the vehicle, left of it on the screen, is going to be her white Mercedes C300.
Okay. And the time on this is August 29th of 2022, and it's at 6:05:48, which we now know is actually 6:06:48, correct?
That's correct.
All right. And what do you, in this particular video, is this where you observed them, or you observed her leave?
This is the video where we observed I observed the white Mercedes C300 leave.
Okay, we're going to move through this because it's somewhat lengthy, but we're going to kind of guide through it until we get to that location. Right. So, Corporal, we did see on that video what appeared to be that Mercedes that you pointed out earlier pull away. Is that what you were notifying or explaining to the jury?
That's correct.
Okay. All right, so now let's go to the next one. No, I think we got it. Yeah, it's okay. I got it. All right. This one's hard because it's not an MP4 file, so be careful. Back trouble with it. All right, so now I put up the second one on the list, and this one is now at 18:56, which is in our term 6:56 p.m., but it's a minute behind, so it's actually 6:57 p.m. Correct?
Correct.
All right. And what are we looking at here around this time? What of relevance comes up in this particular video?
So in this video, in approximately 8 minutes, the Nissan Titan door is going to open and the vehicle is going to drive away.
All right, and that's the truck you were referring to earlier.
That's correct.
Okay. All right, so we just observed that Nissan truck, and that is at 19:04:30, correct?
That's correct.
So that would be 7:04:30 p.m., which we now know is 7:05:30 p.m.
That's correct.
All right. Detective, real quick, because we just kind of looked through that. You've watched that video before, correct?
I have.
Do you see anyone get into that in the passenger side of that vehicle?
Not that I can see from the video.
Are you in the third one? All right, we're going now down to the third video. This is him. Can you get connected? Sorry, Judge, we're having some
That's
technical.
okay. If you
We have it on our laptop. We can
go back to it and go open with and pick the program, sometimes it.
Look it over. What is it currently on? It was on PLC. What are these on? What time? Judge, may Ms. Schlimmer and I approach? Corporal, so we're going to connect to the laptop. It's going to show the exact same thing, and we'll figure out why the disk isn't playing.
Oh, look, it's working.
So now it's working?
He cleaned it off and now it's working.
Okay. Thank you. All right. So now, Corporal, we are now at 22:10:08. What time is that? And like for people who are not on military time?
It's going to be 10:10 p.m. on the video.
Okay. And which we know now is 10:11 p.m.
Correct.
Okay. Detective, real quick, what do we see in this video before? Well, hold on, just go ahead.
Judge, I'm just going to object to the corporal narrative.
That's why I stopped. Now, Corporal, in this video, we see that truck that you described earlier come in, and was that the significance of this video?
It was.
And again, in watching that video, do you ever see any children or anyone get out of the passenger side or anyone else get out of the vehicle other than the driver?
Do you have an object to the corporal narrating the video?
Right, overruled.
I do not.
All right, I'm now going to the fourth one. That's labeled 8/30/2022, 9:09 a.m. All right, Corporal, what is the time on this particular video at this point?
It's going to be 10:18 p.m. with 34 seconds on August 29, 2022 on the video.
Okay. And what's the real time on that?
It's going to be 1 minute ahead of that approximately. So it's 10:19 and 34 seconds.
Okay, yeah, just leave it that way. Corporal, just for Jared, where are we looking at here?
You're going to be looking just to the right of that Titan, to the left of it in the video, but to the right of it physically to the vehicle, which is where Shirley Bass's Mercedes is going to pull back in.
And Corporal, while this is playing, where is their front door in relation to where this video is?
It's just off camera to the right.
So somewhat behind that Nissan truck on the video?
Correct. It's in the video would be in the area behind the truck, sort of obstructed by the leaves of the tree.
Yeah, just leave it. Let it play through. Yeah, just leave it. Now we're going to the fifth one down the line. Now, what's the time on this one?
This is going to be 10:26 and 59 seconds on the video, or 10:27 approximately and 59 seconds in actual time on August 29th, 2022.
So this is approximately 5 or 6 minutes after we just saw the last video.
Compared to the last video, it's approximately 4 minutes at this time.
4 minutes, okay, thank you. So, Detective, we've moved forward a little bit on the video. We're now at what would be 10:30, 37 seconds, or 10:31 in real time.
Correct.
Okay, thanks. Detective, it's now 10:33:10. We see an individual walk past. Did you ever identify who that individual was?
I did.
And who was that?
It was Shirley Bass.
And Corporal, while this is playing, where the individual you identified as Shirley Bass walked to, the individual known as Daquan Evans who called 911, does he live back in that location where she was walking towards?
Yes, he does.
Okay. And Corporal, we're at 10:34:06, and it appears she has something in her hand. Is that correct?
That's correct.
It's up to her ear. I said the phone.
Correct. It looks like she has it at some points at her ear, and then at some points in her hand, and she's looking down at it.
What's the other one? All right, we have one more. This is the last one. What time are we at here?
This is going to be 10:35 and 26 seconds on August 29th, 22nd on the video. However, it's approximately 1 minute later also, so approximately 10:36 p.m. and 26 seconds.
Corporal, we see an individual walking around out there. Were you able to identify who that was?
The person at the far end or the person closer to the tree?
Closer to the tree right there.
I'm not aware if that person was identified personally.
And what do you say, the person at the far end?
There's a person walking around near the area where Shirley Bass's C300 is, and I believe that's Shirley Bass.
Okay. right, Corporal, we are now at 2241 or 1041, which I guess would be 1042. What do we see happening here in the corner up there?
This is capturing the arrival of law enforcement, the first law enforcement officers who arrived at the incident scene.
And do we see the law enforcement interaction with Ms. Bass at that time?
We do.
Okay. Yeah, I just remember. Great, thanks. All right, Corporal, you had reviewed those videos back when you obtained it, correct?
Correct. When the sheriff's office obtained the video, I was able to review it.
Okay. Now, the person you identified as Shirley Bass, how long would you say, or how long were you able to time how long it was when the Mercedes arrived to when she's observed walking out of the house and walking around in the parking lot?
Judge, just again, I'm going to object to the corporal narrating the video.
All right, overruled.
It's approximately 8 minutes.
Okay. So what did you do next in your investigation?
So I forget what our last discussion point was as far as where we were.
You had obtained these videos and observed the videos.
So after observing the videos, in addition to what we've discussed about search warrants, I conducted additional interviews with Shirley Bass.
Okay.
I obtained a search warrant for a buccal swab for the defendant.
All right. Did you learn where Miss Bass had been earlier in the evening?
I did.
And
Objection here, sir.
Oh, not to that question. Overruled.
based on the information you learned about where she had been, did you follow up on that investigation?
I did.
And were you able to confirm that she was at the location that was identified?
I did.
And did you speak to people who were at that location who were there when Ms. Bass was there?
I did.
All right. So where were you able to, the location that she went to, were you able to determine what that location was?
I did.
And what was that?
It was the Ruth's Chris Steakhouse in the West Shore area.
All right. Now, did you ever obtain video that showed the Nissan truck after it left and pulled out on that in the first video we saw, or second video? I'm sorry.
Yes, we did.
Okay. Did you obtain? What did you use to obtain videos to show where that truck had gone?
It's going to be called our HCSO Ion Crime System. The Ion Crime System is a series of cameras strategically placed throughout the county. Some cameras on the Ion Crime System are just cameras. They just record a feed that is captured for a certain period of time in accordance with the law. However, some of those cameras include tag readers, so they're license plate readers or LPRs. Not all intersections include a license plate reader. However, in the District 1 area, in the direction that a vehicle would typically travel to get from the Bass residence at the time to the West Shore area, there were at least 3 intersections that included cameras.
Okay. I'm publishing now what's marked as State's Exhibit number 8 that's been admitted into evidence. The first video I'm going to show, it states Fletcher, North 15th Street, F-160, enter. What are we going to see in this video?
This is going to be, if the order is correct as I recall, this is going to be a daytime video where the sun is out and you're going to see the white Nissan Titan, which is clearly identifiable via it's lifted, it's got the black wheels, the features match Shirley Bass's vehicle, and it's going to be traveling westbound on Fletcher towards the Interstate 275.
So just to orient the jury, that was Fletcher Avenue that we're looking at?
That's correct.
Okay. And you see that truck going towards from the right of the screen to the left of the screen. Is that the westbound direction?
That is.
And that would be heading towards the interstate?
That's correct.
Okay. All right, I'm not sure if these are in the exact right order, so I'm going to play the next one. That says 15th Street pole. All right, Corporal, so once again, we observed that truck you described crossing through. Is this from that same intersection?
It's the same intersection, however, this camera is pointed north on 15th Street.
Okay. And so again, the directionality of that truck on this would be heading west towards the interstate.
That's correct.
All right, I'm gonna save that one. Let's go to. All right, what are we looking at here?
I believe this is 22nd Street, which is to the east. So it is actually going to be slightly before, and there's also going to be the Nissan Titan traveling westbound.
All right, let me play it again. So just so for the jury, where is Fletcher Avenue on this?
Fletcher Avenue is the main road that's going from left to right, and then 22nd Street is the road that's going sort of, this is Fletcher Avenue going left to right, and this is 22nd Street.
And which direction is west for the jury?
West is this way towards the left.
Okay, I'm gonna replay that one since we didn't know that ahead of time, so. Sorry. All right, go to the next one. All right, I'm gonna pause this real quick. And what are we looking at here again?
This is just the same intersection, same time, just another camera also pointed northbound.
Okay.
Actually, I believe this camera may actually be pointed southbound.
All right, so I paused it at 22 seconds into this, or I'm sorry, 11 seconds into this video. We see a vehicle near the Exxon. Is that the vehicle in question that we're talking about, the Nissan truck?
It is, and I misspoke earlier, this camera is pointing northbound.
Okay. And so that Nissan truck would be heading in a westbound direction,
That's correct.
which would be towards the interstate.
That's correct. And this is before the prior video we saw from 15th Street, approximately 1 minute.
Okay. All right, now I'm going down to the one that says Fletcher, Nebraska. Oh, this didn't load properly. All right, it didn't load exactly properly, but what were we looking at in that video? And this is a video that says 9/2/2022 at 9:29 a.m. It says EOC Fletcher, Nebraska. I'll play it again, see if it loads right. No, for some reason it's not loading. Let me pause it right here. Where are we looking at from this video, from what you can see from that part of it?
This is the intersection of Fletcher Avenue and Nebraska Avenue. This is going to be west of 15th Street and even further west from 22nd Street. This is approximately one traffic light or intersection before the highway for Interstate 275. This camera is pointed south. Fletcher Avenue is the main road where that silver vehicle is now traveling east on, and the vehicle in question is going to be traveling west on Fletcher Avenue.
Okay, so it would be going on this video left to right on it, correct?
That's correct.
All right, we just saw it. Was that what we saw past, the Nissan truck?
That's correct.
All right. Now, those were from earlier in the day. Did they correspond and match the times that you recovered those videos from the time that that you observed the Nissan truck leaving the residence at Heritage Club?
The times that we see the vehicle on the Eye on Crime cameras traveling westbound were consistent with the vehicle leaving from the Heritage Club apartment complex and traveling west towards Interstate 275.
All right. Did you obtain video from later in the day showing that vehicle coming in the opposite direction?
Yes, we did.
All right. Not sure why this computer is giving us a hard time. I'm trying to play it again. Not sure why it's not loading properly, but. All right, at that point in time, we just see a white Nissan truck go by. Is that the truck that you are identifying as being the defendant's?
It is.
Okay, and what, do you recall what time it was that this was taken from the poll camera?
This is 22, I believe, 11 hours, so 10, 11 p.m.
Okay, and in this particular, in this video, that truck is heading eastbound, is that accurate?
That's correct.
And that would be back in the direction of where Heritage Club Apartments is?
That's correct.
And does that match up with the time that the truck is actually observed coming back into the apartment complex?
Yes, as part of my investigation, I conducted a query of an approximate timeline it would take to arrive from the intersections where we see the Nissan Titan during that date and that time and that approximate traffic pattern, and it was consistent with the arrival time that we see the Nissan arrive back to the apartment complex.
Finally, the last video, if it loads properly, we'll see. All right. All right, well, I think the jury understands, and so they'll have this back to look at. After obtaining the call detail records, do you obtain a, are you able to learn or follow where that phone goes there throughout that evening?
As part of the receipt of the call detail records pursuant to the search warrant that I authored and was sent over to T-Mobile, I received some location data, which was for the travel location approximate to the cell phone.
Okay, and where did, well, someone else will testify to that, but you, did it confirm that in fact, the vehicle, when the time the vehicle leaves, does it appear that the phone leaves as well?
We object to lack of predicate by the foundation.
Sustained.
Did you observe the map of the location data from where the phones were on that day?
I did.
Okay, and did you compare it with the video that you have of when that Nissan truck, Nissan Titan leaves the residence?
I did.
Okay, and then with the location of travel, did the defendant's phone appear to match the location of travel of the Nissan Titan?
Same objection, Judge.
Sustained.
Did the phone in question, the defendant's phone that you obtained the CDR records from, did it appear to ping or be at location or near location of West Shore?
Same objection, lack of foundation.
Sustained.
Corporal, did you, what did you do with the firearm that was obtained in this case?
That firearm was sent off to FDLE at the time of the initial investigation to FDLE for comparison to the shell casing for cover that the incident.
All right. And did you receive a report back on that?
I did.
All right. Did you submit any swabs to Florida Department of Law Enforcement?
We did. Yes, we did.
All right. And as the lead detective, you know what evidence is being submitted, what evidence is not being submitted, and so forth, correct?
That's correct.
And you can make a decision of what evidence to submit as well, correct?
That's correct.
And did you submit the swabs from the firearm?
Yes.
Okay. And did you obtain any information back from those swabs?
Yes, I did.
Okay. Based on that information, what did you do after that?
I completed, based on the conversation I had with the FDLE personnel responsible for overseeing that submission and the ultimate report, I completed a search warrant for Jermaine Bass, the defendant's DNA.
Okay. And did you submit that?
I did.
All right. And did you obtain a result back from that?
I did.
Based on the results you received from FDLE after the submission of the buccal swab of the defendant, Jermaine Bass, what did you do after that?
I made a determination that I should also write a search warrant for Shirley Bass's DNA.
All right. And did you submit that as well?
After receiving the DNA, I did submit that as well.
Okay. Did you receive a return from Florida Department of Law Enforcement regarding that submission?
I did.
What did you do based on the return from that submission?
I sought to obtain the DNA from Jermaine Bass, and I also submitted the DNA for Jaylah Bass.
Okay.
Jermaine Bass, when I say Jermaine Bass, I mean Jermaine Bass, the victim in this case, often referred to as JJ.
And for JJ, when you obtained the buccal swab, did you in fact go there yourself personally and meet with JJ and obtain the buccal swab?
I did.
And explain to the jury real quick, how does the buccal swab work? How do you do it if you're obtaining it?
Once a court order is signed and I'm authorized to, HCSO is authorized to obtain the buccal swab, I will don a fresh pair of gloves, get my my actual swab, which is a buccal swab. It's sort of like a long Q-tip, if you will. I meet with the person who's providing the sample. I will take the swab, 2 swabs come in 1 pack. I will then insert the swab into that person's mouth, swab both of the sides, the inside of their mouth myself, instead of having them do it. I will then package the swabs into their original packaging, impound them into evidence within an envelope.
Did you do anything else in this investigation?
There was an additional submission I submitted for the firearm recently, which went to our internal HCSO lab for the similar comparison that FDLA completed.
Anything else that you did that you recall?
Additional interviews and additional submissions, evidence impounds, and things of that nature, mostly administrative work.
All right. Did you ever obtain the defendant's phone? Oh, you did, correct? You testified to that earlier. Were you able to download the phone and to review its contents?
The phone was downloaded, however, there was no data of usable data on the download.
Okay. Judge, if I may have a moment?
Yes.
All right, Judge, I'll pass the witness at this time.
Morning, Corporal.
Good morning.
How are you, sir?
Very good.
All right. As you indicated to Mr. Terry, you were in fact the lead detective in this case.
That's correct.
You were with homicide at the time. Since then, you were promoted, and now you're a corporal.
That's correct.
All right. So I want to talk to you first about contact that you had with Shirley Bass throughout this case. Okay?
Yes.
All right. Now, the first time that you had, and correct me if I'm wrong, the first time you had contact with her would have been at Tampa General Hospital on August 30th of 2022 when she was with her niece, China Gadsden.
That is incorrect.
What do I got wrong?
It was at Tampa General Hospital. However, she was with her sister, Marlene Gadsden.
Okay, so and what date was that?
That was the same day.
Oh, okay.
August 30th, 2022 in the morning.
Okay. So the date is correct. It's just not China Gadsden, it's Marlene.
That's correct.
Now, at that time, you took an interview of Shirley and asked her questions about what happened, correct?
That's correct.
And would you agree with me, you asked pretty extensive questions, and it was not a short interview, correct?
Correct. The interview was approximately 1 hour long.
Now, is the next contact going to be on August 31st of 2022? You had made some phone contact with her to have her come back to the hospital because you had went to TGH and she wasn't there. Do you remember that?
Yes, the next day I responded to Tampa General Hospital in the morning. Met with Marlene Gadsden, who advised Shirley Bass had stepped out. I met with hospital staff, who confirmed she had stepped out. So I arranged to meet her I responded later in the day and met with her and conducted a second interview later in the day.
Okay. And in fact, hospital staff has Miss Bass leaving the hospital much earlier than what Marlene told you, correct?
The hospital staff had her leaving at approximately 9:30 in the morning.
Okay, and Marlene gave you a much later time.
Marlene, I believe she told me she stepped out for
Judge, may we
care.
approach?
Sure. Okay, so that's on August 31st, and then at some point Shirley Bass will return to the hospital.
Correct.
Okay, and you then, as you've indicated, conduct a second interview with her that day.
That's correct.
Was anybody else present with you in the room as for the first interview? Anybody present?
In the first interview, present total was me, myself, Detective Vertu, as the law enforcement investigators, and then Shirley Bass and Marlene Gadsden in the room, in that family room within Tampa General Hospital.
And then for the second interview, who's present?
Present with me during the second interview was Detective Brunel, who was another detective in the homicide section at the time of the sheriff's office, and Shirley Bass, and then a CPI was in the interview the entire time. However, during the interview, at some point, for victim services, one of the victim specialists came in the room.
Okay. And that was pretty extensive as well, correct?
That's correct.
All right. Now, I have the third interview being the next day, September 1st of 2022. You have received the surveillance in this case, some of the surveillance we have looked at today, and you had some follow-up questions you wanted to ask Ms. Bass, correct?
That's correct.
All right. That's a shorter interview. That's brief.
Comparatively, yes.
Right. Okay. During the course of this investigation, you found Shirley Bass difficult to reach on the phone if you tried to call her, correct?
At times, yes, she was very difficult to reach on the phone.
Okay. Now, the next contact I have for you, Corporal, is the execution of the search warrant that you got for Shirley's buccal swab. Is that correct?
That's correct.
Okay. And I have that date as May 7th of 2023.
Yes, I believe that's correct.
Okay. And at that time, you got the buccal swab from Miss Bass pursuant to the court order, and you asked her more questions, and you spoke with her about DNA and things like that.
I don't recall the substance. I executed the search warrant. I don't recall much more from the conversation.
Okay. Excuse me. Okay. All right, so the search warrant that you got for Shirley's buccal is going to be similar to the same procedure you would use for a search warrant for Mr. Bass.
That's correct.
Okay. And you also indicated you submitted Jaylah's known profile.
That's correct.
Right? And also when it came to JJ, the son, his buccal swab was also submitted to the Florida Department of Law Enforcement.
That's correct.
All right. Now, did you get a court order search warrant? Was it voluntary for JJ? How did you go about doing his?
At the time of my response to, attempts to get a JJ's.
All right, so we were talking about how you got search warrants and all that for Mr. Bass, Mrs. Bass. The same type of procedure, correct, that you used for JJ?
Yes.
Okay. All right. All of these interviews, the first interview on the 30th, the second interview on the 31st, the shorter interview on 9/1, and the interview for the search warrant of Shirley to get her buccal, you audio taped all of those, correct?
That's correct.
All right. All right, I want to talk to you a little bit about JJ, Jermaine Bass, the son. First of all, could you tell the jury what is the Mary Lee House?
The Mary Lee House is a facility used by law enforcement. In the capacity that we use it, it's used by law enforcement to conduct what's called forensic interviews. That's where a group of trained specialists interview children, because children have their interview procedures are much more delicate and different than an adult interview, or even a teenager interview. Small children are interviewed under a different set of circumstances with a different set of rules and by trained specialists in these types of investigations. So the Mary Lee House facilitates those interviews.
Okay. So it's kid friendly. It's to make the child feel safe.
Yes, I agree.
Okay. Now, is uniformed law enforcement ever present in the interview room when a child is being questioned?
We are not.
Okay. Now, you might be watching via closed caption on video.
That's correct.
Okay. All right. Well, I want to talk to you about the attempts that you made.
Judge, may we approach again?
Yes.
All right, back to what we were talking about. All right, so the first appointment was scheduled for September 7th of 2022 in the morning.
That's correct.
Okay. And who were you with?
I believe at the time I was with Detective Ritu.
With two. Okay. Now, in that situation on that day, you arrived early, did you not?
I did.
Okay. And Miss Bass, at that point, shows up and refused to allow the interview to take place, correct?
Correct.
All right. And basically left Mary Lee House. Is that fair?
She ultimately did leave after a conversation with myself and the detective.
Okay. And in fact, since you were there early, you knew that she had arrived late, correct?
Yes.
All right. But in fact, she asserted she had been waiting an extended period of time.
Objection, Your Honor, hearsay.
Sustained.
All right. All right, so the interview did not take place in the morning of September 7th of 22 that day, correct?
Correct.
All right. And in fact, on that same day, is it true, Corporal, that you didn't even lay eyes on JJ?
That's correct.
Okay. Do you know if she had even brought him that morning?
I'm unable to confirm that personally.
Okay. Now, so when she refused to do the interview, did you take steps then to try to conduct a second interview, or actually a second attempt at an interview, later that day?
I did.
Okay. So we're on the same day, 9/7 of 22, and do you return to Mary Lee House now with Corporal Royal?
I did.
Okay. At that point, the interview did not take place either, did it?
It did not.
Okay. And it did not take place because JJ was uncooperative, correct?
That's correct.
Right. He was hitting his mother.
Correct.
He was poorly behaved.
That's correct.
He was disruptive and refused to speak.
That's correct.
In addition, JJ was being disrespectful to the adults.
That's correct.
So no interview is able to be conducted that afternoon.
That's correct.
All right. Now, At some point, a third attempt at an interview is going to be scheduled for September 12th of 2022.
That's correct.
Okay. Now, at this point, do you go on military leave?
I did.
All right. And who takes over for you on September 12th?
I believe Detective Brunel and or Detective Ratu.
Okay. All right. And they both work with your agency, correct?
That's correct.
All right. And as lead detective, are you aware if the interview actually took place on that date?
It did not.
After that interview, the third attempt on September 12th, did the Sheriff's Department obtain an investigative subpoena and have it served on Shirley Bass?
Yes, we did.
Okay. Tell the jury what is an investigative subpoena.
An investigative subpoena is an order ultimately issued by the state attorney's office commanding a witness to be present for either an interview, typically for an interview, to provide testimony in relation to a case.
Is it voluntary, in other words? Can a person just say, I'm not going to appear?
No, it's not law.
Okay. What could happen if a person doesn't respond to an investigative subpoena?
Potentially, they can face criminal sanctions.
Okay. All right. And as lead detective, you're aware that, in fact, was served on Miss Bass?
That's correct.
And it is served by, I believe, Detective Ratu and or Detective Brunel.
Correct.
All right. Now, then, as lead detective, are you aware that the interview was finally completed on September 23rd of 22? And again, is Detective Ratu in your absence?
That's correct.
Okay. The interview was then able to be completed with JJ.
That's correct.
All right, so is it fair to say then, Corporal, that Shirley Bass was uncooperative with the attempts that were made by the Hillsborough County Sheriff's Office to have her son interviewed?
May I explain?
Well, was she cooperative or not?
There were times where Shirley Bass was uncooperative, and then there were other times where I personally spoke with her where she appeared fully cooperative.
Oh, okay. So half and half. She's cooperative at times, and she's uncooperative.
Correct.
Right. When it comes specifically to her trying to bring her son JJ into the Mary Lee house, however, you found her to specifically be uncooperative, did you not?
Not fully, because there was the occasion in the afternoon where she brought him in and was cooperative with us as we spoke with her.
Okay. You remember giving your deposition in this case?
I do.
All right. What's a deposition? Just tell the jury.
A deposition is where a witness in a matter pertaining to a court proceeding provides testimony to attorneys regarding the case.
Okay. And witnesses are under oath, right?
That's correct.
Okay. And did you in fact testify at that deposition that it is safe to say Shirley Bass was somewhat uncooperative when it came to attempts to interview her son?
Yes, that's
Okay.
accurate.
All right. Thank you. And finally, before I leave discussing Mrs. Bass, I want to show you a transcript of the audio you did when you executed the search warrant on Shirley Bass, and it is just to refresh your memory if you discussed other things. Okay? That's all I'm going to ask. When you have this, I'll send it to you. All right. May I put your witness touch?
Yes.
Okay. I'm handing you a copy of what has been transcribed as Shirley Bass search warrant execution. And this has been previously supplied to Mr. Terry. I don't want you to discuss the contents. Just look through it. And I'm going to ask you again if that refreshes your memory of when you took the buckle. Did you discuss other things with her? Have you had a chance to look at a copy of the transcript of the execution of the search warrant audio that you conducted?
I did.
And does that refresh your memory as to whether you asked Shirley questions and you spoke with her? You didn't just take the buckle, correct?
That's correct.
All right, thank you. I'll go ahead and take that back. Thank you so much. Now, you do have two contacts with Mr. Bass, correct?
Yes.
Do you remember? Okay. And basically, on those two occasions when you had contacts with him, he was cooperative with you and with your crime scene unit.
That's correct.
Right. You had contact with him collecting his clothes, taking photographs on August 30th. Sound correct?
That's correct.
All right. And then you went back to get his vehicle, like we've talked about everybody else's, on October 10th of 2022.
That's correct.
All right. Now, in this case, there's actually two separate 911 calls. Daquan Evans calls, Shirley gets on the line. At some point, for whatever reason, the call is dropped, and then there's a call back. Correct?
That's correct.
All right. And it is a true statement to say that you cannot fire 9mm ammo in a .380 automatic, semi-automatic.
As I understand from my experience with firearms, that is correct.
Okay. All right. Now, did you know anything as lead detective about the brown purse that was located in the children's closet?
No.
Okay. Were you aware, or are you aware as you sit here today, that there was .380 ammo in a box in a purse in the children's closet?
I was made aware shortly or during this trial that.
Okay. You found out during the trial?
I found out during the trial.
2.5 years after this incident?
That's correct.
Okay. All right. Now, you had indicated that Mr. Bass's blue iPhone had been collected at the crime scene, correct?
That's correct.
All right. And you indicated you did looked at it and there was no significant or anything of evidentiary value for you to tell the jury about, correct?
That's correct.
And in fact, you did a Cellbrite download?
I
Or tried to?
I don't conduct the downloads, but I believe at the time, Cellbrite was the application used to download the phone.
Okay. So that's what Cellbrite is? It's just kind of like you connect it to the phone and it'll shoot out all the data from the phone?
Yes. Cellbrite is a program that is, I believe, generates the report for reviewing the phones.
Okay. And that's pretty standard and routine that you will do that in cases where you'll have a phone, you get the search warrant, and you're able to attempt to do downloads of the phone.
Correct.
Photographs, you could get text messages, phone calls, social media, all of that.
That's correct.
And getting a search warrant from Mr. Bass's phone, that is also fairly routine as part of your job, correct?
That's correct.
All right. I wanted to ask you what you got in relation to that search warrant that you did for Mr. Bass's iPhone that was in the crime scene. You requested in your search warrant cell site lists. Do you remember that?
In the search warrant for the physical phone or the search warrant for the data?
The data.
Yes.
Okay. And in paragraph 7 of your search warrant, do you remember requesting timing advance records?
That's correct.
Okay. Do you know, as you sit here today, Corporal, what records you received in this case from T-Mobile pursuant to that search warrant?
I don't recall all of the records as I sit here right now. However, I do recall receiving call detail records and I believe data sessions, which are related internet connection, location information.
Do you know, and if you don't, it's fine, if you received anything above the call detail record?
I don't recall.
Okay. And did you, in fact, ask Bethany Ross to do some work concerning Mr. Bass's call detail records?
I did.
Okay. I want to talk just a little bit about Mr. Bass's call detail records that we looked at here today. You had mentioned something about a phone call. It looks like it was 2234. Mr. Bass's phone makes an outgoing call to a number you believe to belong to his mother.
That's correct.
Okay. And was that call answered, do you know?
Based on the time, the duration of the call, it says completed successfully. However, based on the 5-second duration, like I stated previously, that is consistent with me to be where the voicemail answered the call. The call was not answered by a person, it went straight to voicemail.
Okay. In fact, the CDR lists 5 seconds.
That's correct.
All right. So, and as lead detective in this case, you're aware that the 911 call was at 2233.
That's correct.
Right. So the 911 call is being made at 2233, and a minute later, Mr. Bass attempts to call his mother, correct?
That's correct.
Right. Okay. All right. Now, I want to talk about Shirley Bass and the attempts you made in order to get her phone. Now, as lead detective, are you in fact aware that
Again, may I approach?
Yes.
Okay, so you're aware that a Deputy Creasy, had entered the crime scene and retrieved Ms. Bass's phone for her?
Correct.
Okay. All right, and you were never able, as you sit here today, to do any sort of download from Shirley's phone.
That's correct.
Now, you did get a CDR, a call detailed record for Shirley Bass,
That's correct.
right? And you do that via a subpoena.
That's correct.
Right, because you can get a call detailed record with a subpoena, but you need a search warrant to get into the physical phone.
That's correct.
Is that fair? Okay. Now, who were you with when you spoke with Miss Bass at the hospital concerning taking her phone? Do you remember if you were with Detective Brunel or Detective Spencer?
I would have been, I believe, with Detective number 2 on the first time and Detective Brunel on the second time of that day.
And when you say that second time, are these multiple attempts to try to ask her to give you the phone to download?
I believe it was all on the 31st. So the first time would have been when I spoke, when I attempted to speak with her, she wasn't there. I was interested in getting the phone then, and ultimately I did ask her about the phone when I was present with Detective Brunel.
Okay. And in fact, you even offered with Detective Brunel, look, stay at the hospital. We'll take your phone.
Objection here, State Judge.
Sustained.
You offered to take her phone, download it, and return it to her at the
Hearsay.
Sustained.
You never got Shirley Bass's phone, correct?
That's correct.
You were never able to download it, correct?
That's correct.
Okay. All right, I want to ask you a little bit about China Gadsden. I understand that's Mrs. Bass's niece.
Yes, it is.
Okay. And you conducted an interview of her on October 23rd of 2023. Does that sound accurate?
That's correct.
All right. And prior to that date, in late 2023, there had never been anything relayed to you about a supposed meetup between Mr. Bass and his wife Shirley in China in their vehicle.
That's correct.
And in fact, there were times, and I don't know if it's once or twice, you can tell me, that you tried to call China Gadsden to speak with her, and she would hang up on you.
That's correct.
Right? You actually audioed that so we could hear it.
That's correct.
All right. The next topic I want to talk to you just a little bit about is some of the things that were done in this investigation. Did you ever request, or are you aware of any gunshot residue testing done on Mr. Bass's hands?
No.
Did you request, or are you aware of any gunshot residue testing done on Miss Bass?
No.
Either child, Jaylah or JJ?
No.
Okay. And you do not attend the autopsy, correct?
That's correct.
All right. And are you privy, were you the one to have any conversations with the medical examiner's office concerning the issue of potentially getting GSR done on Jaylah's hands?
No.
Okay. And in your situation, when you work for the sheriff's department, you're the lead, Ratu is your assist, Holbelman is the crime scene detective, and you're going to have other detectives that are going to help you out and do things in the investigation.
That's correct.
You've mentioned some names. We mentioned Brunel, Detective Spencer. Those ladies and other detectives helped in this investigation.
That's correct.
Okay. Shannon Bader had looked at the Mandalorian comforter and had used an infrared light and a swabbing to see if there was any gunshot residue on that. So I wanted to ask you, what follow-up did you do concerning what she took off the blanket or what she photographed?
There was no, I wasn't aware, the Mandalorian blanket, the primary follow-up was done after, later in the investigation related to blood.
Right, it's done later. Okay. So as lead detective, are you aware that she used infrared light and looked to see if there was gunshot residue and actually swabbed it? Are you aware of that?
Not specifically.
Okay. So it's safe to say, as lead detective, you are not aware, as you sit here today, of any results if Ms. Bader had in fact swabbed that comforter for GSR.
That's correct.
All right. Let's talk to you just a little bit then about the video we looked at. You had mentioned, I want to make sure I have the times correctly. Did you say that the Mercedes leaves the apartment at 16:18? Was that right?
That was, so the 16:18 time is what I documented in my report.
Okay.
That is ultimately going to be because of a miscommunication in the initial message I received from Detective, I believe her name is, it was Detective Wheaton at the time, who was with Detective Spencer in the video collection. And the initial report I received was that the time was 16:18, but that ended up being incorrect. It was a typo. It was approximately 18:10 or 18:11.
Okay, about 18:10. And I'm not counting the 1 minute Mr. Terry has fixed with you because there was like a minute behind. Right?
Yes.
Okay. All right, so that's then 6:10 p.m.?
6:10 p.m.
Okay. And the Titan leaves 19:04?
Correct.
Okay, so that's going to be about 7:04?
Correct.
Okay. So then you do admit to this jury that you documented throughout your report that it was 16:18 that the Mercedes left and 19:04 that the Titan left, being a difference of 3 hours.
That's correct.
Okay. And do you also admit to this jury that you, in fact, did testify to that in your deposition as well?
Potentially, yes,
Okay.
yes.
All right. And in fact, one other spot, do you admit to this jury that, in fact, that's what you put in the search warrant in this case?
Potentially, yes, because that's what would have been at the time what I would have been relayed, that would have been relayed to me until I fully watched the video myself.
Okay. And I'm not asking what was relayed to you, but who did you speak to about that?
That would have been, I believe, again, Detective Spencer and Detective Wheaton, whose name is now Detective Miley, would have been working together at that time. I believe I actually spoke with now Detective Miley.
Okay. All right. Thank you. That's Wheaton.
Correct.
It was Wheaton. All right. Now, I didn't see any video from the Ion crime from anywhere near the West Shore area. Did I miss something?
There was no video, there's no Ion crime in the West Shore area.
Okay. Where is Ion crime throughout the county?
I'm not sure of every location. It's strategically placed by the Hillsborough County Sheriff's Office.
Okay. There's definitely some over up on Fletcher that we saw, correct?
That's correct.
All right. So all of the video that we looked at, that had to do with areas around Fletcher, correct?
Correct.
All right. How are you able to tell if you see a white truck pass by, like we saw, we're watching cars drive by, heading to or from the interstate. How do you even tell that that is Mr. Bass's Titan?
You can definitively say which vehicle it is when there is a plate read. However, there's not always a plate read because not every plate that passes by a camera is captured for various reasons, and not every intersection or camera has license plate readers.
Okay. So there's no license plate reader in this case, or is there?
I'm not the license plate reader image. If it was the scan, it's not captured in this case.
Okay, all right. So in fact, the video we looked at, you cannot definitively say, Corporal, that that is Mr. Bass's white truck, correct?
May I explain?
Go ahead.
Based on the visible features, I believe it to be Mr. Bass's truck. Absent that, I cannot say the license plate of the vehicle, but that license plate was attached to that vehicle as it passes by the cameras.
Gotcha. What type of visible features would be unique on a white truck?
Well, in this case, it's the make and model, which is the Nissan Titan. It's approximate year range based on its grille design. For example, the Nissan Titan was released for multiple model years, a very long time span. There was design changes in its exterior. It's raised and it had black wheels, the same features that were visible in Shirley Bass's vehicle.
Is that typical to all Nissan Titans?
Not every Nissan Titan would have those features.
Okay. Do you know the features of all Nissan Titans that are located within Hillsborough County?
I do not.
Okay. And when we looked at the video coming and going from the apartment complex, I didn't see people going in and out of cars. Did I miss something?
In both the vehicles, there is a figure that walks to the driver door of both vehicles that is visible in the video. However, their distinguishing features, who they are, is not visible in the video.
Okay. Okay. And I have a moment. Please. Corporal, thank you so much. We don't have any further questions.
Morning again, Corporal.
Yeah.
So, Corporal, you told the jury when it comes to regards to Shirley Bass, she was cooperative at times, correct?
That's correct.
Okay. In fact, the day her child was murdered, she spoke with you for over an hour.
Objection, leading.
Sustained.
On the day she was murdered, did you attempt to interview her then?
I did.
And did she speak with you then?
She did.
How long did she speak with you?
Approximately 1 hour.
All right. And was it the day after, or how long after that you spoke with her the second time?
Approximately 1 day later.
Okay. And she spoke with you then?
Yes, she did.
And how long did she speak with you then?
Even longer. I believe it was approximately 2 hours.
Okay. Now, let's go to this attempt to interview JJ. Do you know the reasons why she did not want to have you interview JJ?
She specifically told
Well, don't
me.
without telling you. Did she tell you?
She did tell me.
Okay. Now, let's set the stage for this. This was on September the 7th, correct?
Yes, it was.
Okay. Her daughter had been killed on August the 30th, so approximately a week before.
That's correct.
Do you know whether she'd even had the funeral at this time?
Objection, relevance?
Overruled.
I know she was planning a funeral.
Okay. Her son had just gotten out of the hospital. Did the son just get out of the hospital?
Correct. I believe 1 day prior.
And he had been severely injured.
That's correct.
and this is his mom, who you are now asking to bring to this location with some strangers to talk.
Objection, leaving.
Sustained.
The phone in question, Ms. Bass's phone, she did not give you the phone. Did she give you the phone?
She did not.
Okay. There are ways you can get a search warrant, right, for a phone?
That's correct.
But you need what do you need to get a search warrant for a phone?
To get a search warrant for a phone requires probable cause.
Did you have any probable cause to get a search warrant for her phone?
I did not believe I did, based on the facts known to me at the time of the investigation.
And let's go back to the facts known to you at the time of the investigation. She asked, did you test for gunshot residue on the defendant's hand? Did you? You didn't do that.
Correct, we did not.
Did you know at the time that the defendant admitted he fired that gun?
I did.
Did you think that would add anything to the evidence?
I did not.
In fact, your understanding when you got there based on his statements was that he fired that gun.
Objection, leading.
Sustained.
Based on your understanding of what the defendant said, what was your understanding of what happened there that day?
Objection, improper opinion.
Sustained.
Did what he tell you affect how you do your investigation? Did what you hear what he said happen affect how you conduct an investigation?
It did.
Okay. Thank you, Judge. Nothing further.
All right. You can step down, sir. Thank you. He released from his subpoena?
He is not.
Okay. Is he to remain at the courthouse?
He is.
All right. Thank you. We'll take a quick comfort break, I believe, the jurors have asked, so we'll be in recess.
All rise.
Consider having been proved beyond a reasonable doubt in that the parties are not in dispute about this evidence. And in this case, the stipulation is as follows. Jermaine Bass, JJ, the son of the defendant, the victim named in counts 3 and 4 in the indictment in this cause, has been interviewed by both the defense and the state of Florida. Both sides agree that JJ has no memory of the events leading up to or occurring on the night of August 29th, 2022. Due to his lack of memory, the state and defense agree that he will not be called as a witness. And this stipulation or agreement is signed by Ms. Schlemmer, by Mr. Bass, and by Mr. Terry, the state attorney, and dated today's date. Any questions on that? All right. You can call your next witness.
State Attorney Bethany Ross.
Raise your right hand, please. Do you solemnly swear or affirm that the testimony that you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
You certainly swear.
If you would please introduce yourself and spell your name for us.
Bethany Ross, Bethanyross.
Thank you.
Good afternoon, Mr. Ross. Oh, it's still morning. Good morning.
Good morning.
Please turn to the jury and tell them where you work.
The Hillsborough County Sheriff's Office.
How long have you worked for the Hillsborough County Sheriff's Office?
It'll be 10 years next month.
What do you do there?
I'm a criminal intelligence analyst in the Criminal Investigations Division.
How long have you been a criminal intelligence analyst?
About 6.5 years.
What did you do before that?
I was a deputy for about 3.5 years.
Now, when you become a criminal intelligence analyst, what's required of you when you transfer from being a deputy to a criminal intelligence analyst?
Yeah, you're learning completely new technology, completely new applications. It's all about getting information that the detectives may need for their case, and then obviously in a prosecution of a case later as well.
Give us some examples so the jury can understand what kind of things you work on during your experience as a criminal intelligence analyst.
So I help identify people in a case, I help give them vehicle information, stuff like that, and then I also map a lot of different things, such as cell records.
So when you're talking about mapping cell records, help us understand the process. What goes into mapping cell phone records?
We get provider information, such as T-Mobile, AT&T, and Verizon. They give us like an Excel document that has latitude and longitude of, say, like the cell phone tower that cell phone connected to, and from there you can map that information.
Are you the one who generally requests these records from providers such as T-Mobile or Verizon?
No,
Who usually does that?
the detectives.
Now, once the detectives receive that information, what kind of information is usually inside of the packet that you get?
Yeah, there's got to be a date, a time, that phone number, the target phone number that they were looking for, who that phone number was talking to, if it was voice records, and then it would also be the tower information so that you can map that information.
I'm showing you what's been entered into evidence, and I'll put it on the Elmo here if I can have some help. Thank you. this is what's been entered into evidence as States 29. Is this an example of some of those records that you would receive in order to do your job as a criminal intelligence analyst?
Yes.
Okay, and did you in fact receive the documents from T-Mobile in this case that are included in this States 29 involving the defendant, in this case, Jermaine Bass?
I did.
When you receive these documents, help us understand what is the first thing you do when you receive call records from, in this case, for instance, T-Mobile?
I make sure that it has the relevant time that we are looking for, that it is the correct phone number, and then that there is mappable information within those records.
How do you know whether or not there is mappable information in the records when you receive it?
It's filled out in the latitude and longitude columns. It's filled out in the E-node columns, everything that denotes that a tower is being used and that tower information is present.
Explain to the jury how you became involved in this investigation involving the defendant, in this case, Jermaine Bass Jr.
The lead detective, Detective Gabo, asked me to map a certain time period of these records.
Now, tell us the phone number associated with the records that you were asked to map. And if you need your memory refreshed by your report or your map, let me know and I can do that.
Yes, I would have to look at the records for that.
Okay, I'm showing you what's been entered into evidence as States Exhibit 21. Is this a map you created along with your experience and involvement in this investigation?
It is, yeah.
Can you read out to the jury the phone number that was used in order to map in this investigation?
That's 813-696-7195.
Do I have permission to publish to the jury, Your Honor?
Yes.
To aid in your testimony, before I do that, so you receive these T-Mobile records, you make sure that they have information that is mappable. What do you do after that?
From there, we use a program called CellHawk that actually takes that file and creates that map so that it's not like I'm hand drawing it. It can make that map.
You told us that you've been a criminal intelligence analyst for, what, 6 years?
Yes.
During that process of becoming a criminal intelligence analyst, did you receive training in how to use this program that you described as being called CellHawk?
Yes.
What's the training involved? Just briefly describe it for us.
Yeah, they take you through every step of getting the records, looking at the records, and then mapping those records and how to interpret that information.
When you put the records into the program, does it map it for you?
It does.
Then what do you do after it produces, this program produces the map?
I take a screenshot of that in order to put it in a document with all of that original information that we got from T-Mobile so that we can see it together.
So when you initially become a criminal intelligence analyst and you learn how to use CellHawk, do you maintain any sort of continuing education on the changes that happens with updating technology?
I do. I have to keep up to date with that stuff because it changes constantly. So at least once a year, there's webinars and a lot of different information out there that I'll keep up with.
And do you maintain that continuing education for the CellHawk process?
I do.
Tell the jury approximately how many times during your career as a criminal intelligence analyst that you've used this mapping process with this program called CellHawk.
Hundreds of times.
So in this case, the investigation involving Jermaine Bass Jr., the defendant, you receive his cell phone records from, who's the provider?
T-Mobile.
And tell the jury what you do next.
Once I have that screenshot, then I will put it together in a document to give to detectives and put in the case.
So I'm placing on the Elmo what's been entered into evidence as States 21. Is what we're looking at in States 21 an example of the mapping that you just discussed?
Yes.
So you use the information provided within the T-Mobile records, you put it in this program, and this is what it spits out.
The screenshot is, exactly.
Okay, so I want to talk about the map. Let's orient the jury what we're looking for in the map, okay? On the bottom left-hand portion, I see West Shore. I'm pointing to it with my finger. In fact, there is a line right through the word West Shore. Is that West Shore Boulevard here in Tampa?
Yeah, West Shore Boulevard is in that area, and that West Shore is denoting that that's kind of the area, West Shore.
Right above that, we see another line and it's two lines together. It looks like almost kind of a pie chart situation right above Tampa International Airport. Is that correct?
Exactly.
Oh, sure. And for the record, I'm zooming in so that we get a closer look at what I just pointed out to be the West Shore in the bottom left-hand corner area and what the witness has described as Tampa International Airport right before that. Right to the left of Tampa International Airport, we see symbols that look like it would be some sort of highway with a circle, a white circle that has numbers on it. What is that representing?
Yeah, that's showing 589, excuse me, and this is using actually like Google Maps information.
And then if we go up in the middle, we're seeing two half pie graph almost situations. To the right of that, we're seeing University Square. Tell us what area we're looking at now.
Yeah, the University area or the University Square area.
Right through that, we see yellow lines and a marker that is commonly known to be an interstate marker. Tell the jury what interstate marker that would be.
I-275.
Tell us about the text boxes that we see on the map. We're going to go one by one, but a general understanding of where does this information come from. Does the CellHawk program produce the map along with these text boxes?
No, the CellHawk program gave me that map, and from there I go back to those records to copy paste this tower information, the date and time, and that incoming or outgoing call information, along with the duration, into these little text boxes so that I can show exactly how that tower relates to the information that T-Mobile gave us.
Now, throughout the map, and again, we'll go one by one, we see what looks like lines that have like a half circle on them. I also see one that is a full circle. What do those symbolize? Just so the jury understands before we go one by one.
For that full circle, T-Mobile is not able to give us a direction, so we just have a 360 around the tower. For example, to the left of that, it's showing kind of southeast, and that means T-Mobile was able to give us a direction, which is southeast of that tower.
So what do these markers or the pie graphs or the circle, what does it indicate? You're saying it indicates a tower, but what about the tower?
That tower was in communication with that cell phone during that incoming or outgoing call.
So the purpose of the shape or the marker on the map shows us where the cell phone is at any given time?
It at least shows the direction from the tower that the cell phone was in.
Okay, so I want to start at the top text box. We see a full circle, which again indicates to you that the cell phone is bouncing off this tower, correct?
Yes. Yes,
But it's not indicating to you a location in which it's heading. Is that safe to say?
exactly.
Now, we see a line with, it's an arrow to the right of the circle, and we see a text box that I'm pointing to. It's the topmost portion on the right side text box. Explain to us what that means, that text box.
It starts with the E node B, the sector, and the azimuth, which is all going to be tower information. That azimuth is blank. I just have a dash there because we don't have a direction, and that's actually where that would come from. The location is followed by that, and that's literally the latitude and longitude of the tower. And then we have the date and the time, and it was an incoming call from this phone number, 361-217-7632, and the duration is 0 seconds. There was no duration.
So we have that at 6:04:03 p.m. Next in time, we see to the left two lines intersecting, right encompassing the words University Mall. It encompasses the two first letters U and N. Explain to the jury, and if you need to stand up and point or come over here and point, Judge, does she have permission to do that?
Sure.
If you
Probably
can,
going to you is probably best.
yes, ma'am. If you can please come around so that you can point to yourself on the Elmo.
Make sure you describe with words too.
So specifically, and I'm going to rearrange. We see a top text box on the top left corner. I'm pointing to it right now. From that text box, we see a red or orange arrow pointing to the pie graph encompassing the first two letters of the word University Mall. Now, I noticed that this graph we're looking at, the symbol is different than the circle. And if you don't mind, can you come around this way and stand right there to point so that we're just not blocking the jurors? Can you point to the University Mall one and explain to the jury the difference between the circle we just saw and the information that it provides to you, and this pie graph that we're looking at that's kind of like a semicircle with two lines? What's the difference?
So in the original one, the circle, right in the middle of that is going to be where that tower is, where that line is inside that circle. Instead, on this one, it's where these two lines meet. The tower is actually going to be right there, and we get that southeast direction because it's kind of facing southeast.
The semicircle that we see shaded in connecting those two lines, what does the semicircle symbolize to you?
This is just a display. It's half a mile out from the tower. That does not mean that the cell phone was half a mile out from the tower. It's a traditional kind of display for this type of information. And
let's talk about the text box that's associated. We pointed out before the topmost left one. We see it says the E node B, the sector, and explain to us, the one before didn't have an azimuth. What is an azimuth?
Yeah, this azimuth is 120, and that's a degree out of 360 of a circle. So that 120 gives us the southeast. That's what the azimuth is.
So the 120 or the numbers next to the word azimuth indicate to you a directionality.
Exactly.
Of the cell phone itself or of the tower.
That's the direction the cell phone was in from the tower.
So the cell phone in relation to the tower, you can tell to a certain degree.
Yes.
Okay, so in this one we see 120. Now we see the location, which you indicated before is latitude and longitude, is that correct?
Exactly.
We see the date 8/29/2022 at 7:15:21 p.m. Tell us what the outgoing call number is.
That's 813-516-5632. 3376.
Now, outgoing call, does that mean the number listed above, 813-696-7195, is the one who dialed out?
Exactly.
And if we see a label later on, incoming call, does that mean that the number listed below the words incoming call placed the call and dialed to 813-696-7195?
Exactly.
Okay, so the next in time, we see 7:16:04 p.m. For the record, I am pointing out a text box that is the second from the top on the top left side. We see an arrow coming from that, pointing to two lines that intersect with a semicircle. It is right below, encompassing the bottom portion of the N on North Tampa. I see that to be to the left of Busch Gardens, Tampa Bay. Is that correct?
Yes.
Now, tell us what information you were able to receive and what that line and semicircle means to you based on this information.
So exactly like before, those two lines intersect, and that's where the tower is. But what's different this time is it's facing northeast. In addition, we've got this incoming call from 813-516-3376, and it was a duration of 65 seconds.
So this number, 813-516-3376, placed a call that was answered by 813-696-7195, and we previously identified that the 696-7195 belongs to the defendant. So let's talk about the next call in time. We see, let me get it on the map correctly. 8:37 p.m. We see it's the third text box on the left side, touching the left portion of the map. We see arrow coming below, and we see two lines with a semicircle right above the word Tampa International Airport. Tell us what information you were able to gather during your investigation about this specific time, August 29th, 2022 at 8:37:56 p.m.
There's actually another one that's at 8:20, which was just before it.
Oh, thank you. Okay, so 8:20, here we go. 8:20 and 43 seconds. We see this one almost looks like a straight line with more of a semicircle than we've seen before, right below the words West Shore, with an arrow coming out the bottom corner of a text box. If you're looking at the graph, it would be second from the bottom text box to the left. We see at 8:29:22, at 8:20:43 p.m. Tell us what that symbol is, because it looks a little different than the other ones that we've seen so far.
I had to divide this one into the left sector and the right sector because that tower is used multiple times, but with different sectors. So this one in particular, 8:20, is the left sector, this one right here.
Okay.
And that's going to be an incoming call from the 727-315-3379 number. And the division.
It's 3329.
Oh, I'm sorry about
Well,
that.
you are backwards, so it's okay. Yes.
And that duration is 0 seconds on that one.
Okay, so what does the 0 seconds indicate to you?
It most likely was not answered, or it didn't complete.
Okay, so that's 8:20 and 43 seconds. Then we have 8:37 and 56 seconds. This is the one that we were talking about before, where there is a symbols above Tampa International Airport. Tell us what you know from your investigation of this specific symbol at 8:29 on August 29th of 2022 at 8:37:56 p.m.
So this one is facing practically north, and it's an incoming call from 727, let me not mess this up, 315-3329, and that duration is 0. I'm gonna make sure this is in the correct position. So then we see a text box on the right, it's the right bottom quarter, and we see at 8:29:22 at 10 o'clock with 30 seconds p.m. Tell us what information that you were able to gather during your investigation about this specific area. So we are now on the right side of this tower that we talked about before, that's just in this West Shore area. And this is an outgoing call to 727-315-3329, and it was a duration of 15 seconds. Right below that, included in the same text box, we see 8:29:22 at 10 p.m. and 54 seconds. Tell us what you were able to learn about that specific hit off the cell tower. Yep, same. It's the same right side. The outgoing call to 727-315-3329 for 5 seconds. Let's move below the bottommost portion. We have, there we go, it's centered now, a text box on the bottom. And we see at 8:29 of 2022, 10:01 p.m. and 43 seconds, an outgoing call to 727-315-3329 with a duration of 43 seconds. Show the jury where that cell tower pinged. So the tower is right here where these two lines intersect, and we're a little bit farther south from the other tower that we've been talking about, still in the West Shore area, and it's facing basically north or northeast.
Now we're going to, we're looking at the top quadrant. We've already discussed the topmost portion of the text box. And we see that the circle that we have has an arrow next to it in the text box we already talked about from 6:04 p.m. But below that, it looks like there's 2 other phone calls. So I want to discuss 8/29/2022 at 10:19 p.m. and 37 seconds. Tell us what you learned during your investigation.
So it is this one with the full circle here, and it is an incoming call from 727-315-3329.
Below that, oh, sorry, go ahead. Okay. Below that, we see it's within the same text box, August 29th of 2022. We see at 10:34 p.m. and 58 seconds. Tell the jury what you found out during your investigation.
That one is an outgoing call, and it is to 813-516-3379, and that duration is 5 seconds.
And that information indicates to you that this phone number belonging to the defendant called out at 10:34 p.m. and 58 seconds, correct?
Yes.
May I have just a moment, Judge? I don't have any further questions.
All right.
Do you want this?
Cross.
Good morning.
Good morning.
All right, so you are not here today testifying as an expert in cell phone mapping, correct?
I don't know if they've listed me as an expert or I don't know.
All right. Have you ever been in court before and you are declared an expert? Are you aware of anything like that?
There was one time during a federal trial, yes.
Oh, okay. All right. All right. So basically, let me get the gist of what you do. You receive a CDR, correct?
Yes.
In this case, you received a CDR of Jermaine Bass, our client.
Yes.
Right. You took that CDR, you plug it into CellHawk, which is the program.
Yes.
All right. And in your own words, CellHawk spits out the data, right?
It creates the map, yes.
Creates the map, right? And you said something about a screenshot. So CellHawk creates the map. Is it going to create exactly what we're looking at besides your additional boxes?
Exactly.
Okay. You take a screenshot of it, and then you're going to go, what, back to the CDR, the same CDR you used, and make your little boxes?
Exactly.
Got it. Okay. What else do you do?
After that, I need to put it all together in this document, and this is a header that we typically use on all of these documents, so I add that header, and I'll add my signature and the date.
Okay. Like prepared by
Exactly.
CIA Ross, and then a PRHCO case. Okay. What do you do to validate what CellHawk has told you?
So what's good is with latitude and longitude, you're able to throw that into Google Earth, Google Map, whatever, and that is able to show the exact pinpoint that CellHawk has made where that tower is. That's how you can verify those records.
Okay. So is that your testimony that that's how you're verifying the CDR?
Yes.
Okay. But that again is going to come, the latitude and longitude, from that CDR.
From T-Mobile, yes.
Okay. Now, in terms of where a tower is located, did you do any verification of what CellHawk spit out by doing a drive test?
No, that's not typical for us.
Were you ever requested to do a drive test?
No.
All right. This CDR that you were given it by Detective Gabot, correct?
Yes.
All right. He gave you a specific date and a specific time?
Yes.
All right. You did not receive CDRs from any other individuals, correct?
No, not that I recall.
Okay. I wanted to ask you a little bit about, for example, when we see a 0 duration in the map you made, you agree with me that T-Mobile doesn't really give you in very plain, simple English if a specific call with a 0, if it was answered or not, correct?
Exactly. You have to, yeah, you don't know.
You don't know, okay. And in fact, isn't it true that there could actually be other calls as well that are not mapped? CellHawk doesn't map them because, for example, there are some reasons it just didn't connect, that call didn't connect to the tower, it was iPhone to iPhone, or there could be signal issues. So there might be other calls, and for some of those reasons, they won't get spit out by CellHawk.
Yes, they can't be mapped because that mapping information just doesn't exist.
Right. Okay. Now, did you use a cell site list to verify your data?
Yes.
Okay. Which cell site list did you use?
So T-Mobile has uploaded to the CAST team on LEAP. It's a government website that the FBI uses. They have cell phone towers uploaded into there on a regular basis, and that's the one that we use within CellHawk.
Okay. Did you use it specifically in this case?
I did.
Okay. Which version, or what was the date, or approximate date, of the cell site list from T-Mobile did you use?
October of 2022.
All right. Were you aware that in August of 2022, T-Mobile and Sprint merged?
I don't know the exact date, but I know that they merged.
Okay.
Yes.
And you used October. Is there another one also in December of 2022?
There should be, yes.
Okay. Now, when you're on CellHawk, you get a little box that even pops up and tells you, you better use that cell site list because that's the best practice, right?
Exactly.
All right. And it's your testimony you did that in this case?
Yes.
Okay. I wanted to ask you and just clarify a little bit about this azimuth. So let's look at the one from 715. For example, we have it as upper left-hand corner of your map, 71521, pointing over to that very first, what do you call that? With the lines in the shaded circle.
Right here.
What do you call that?
This is like a sector.
Sector, okay. And so that's that first sector, correct?
Yes.
All right. So now, what is the azimuth for that sector?
That one's 120.
What does that mean?
It's 120 degrees of that 360 degree of a full circle. So they choose 120 to be that southeast portion.
Southeast portion, all right. So you're not telling us that that phone is in that shaded portion, correct?
Exactly, that is not the case.
Right. What's the radius? Can you tell us what the radius would be of where that phone may be?
No, these towers, this information does not have like a radius and a distance from the tower, just the direction.
Right. So in fact, all you can tell us is what you have plotted, that that cell phone is in that direction from that tower.
Exactly.
Okay. It doesn't mean it's in that shaded area at the time.
Right, exactly.
It just means it's in the direction from the tower. So in this case, we would have, I think you said, is it southeast, or for that first one at 715?
Southeast.
Southeast, okay. So we don't know how far, it's not in the shaded area, but somewhere that phone is in that direction, southeast, from that area.
Exactly.
Okay. Simple as that, right?
Yes.
Okay. So you're not telling this jury you can place an exact location of a phone.
I cannot.
Okay, you cannot give us a location if it's at a restaurant or sitting on the interstate, you can't give us any of that, correct?
Right.
Okay. And you cannot, with the records you received in this case, give us any idea how close to the tower itself that phone may be.
Right.
Okay. Did you ever receive timing advance records in this case?
I don't recall if I did or not.
Are those a little bit more accurate in?
So they may have that distance from the tower that we talked about before.
Gotcha. Are you aware that when Detective Gabot did his search warrant in this case, and he just talked about it, that he requested timing advance records?
I don't know.
You use timing advance records pretty commonly in this,
Yes, when we do get them.
and you're going to get better information.
Sometimes, yeah.
Okay. So in this specific case, the only thing you had was the CDR data, not any sort of more accurate timing advance records.
As far as I remember, yeah.
Okay. All right. Besides the CDR itself, and we have it in evidence here, what else do you recall actually receiving from T-Mobile, if anything?
It comes with possibly data information. It depends on how they package it and give it to us. But I use just the voice records on this one.
All right, we're not talking about data, use of data.
No.
Okay. All right. Looking at my notes to see if I have any other questions for you. May I have a moment?
Yeah.
Thank you, Judge. My co-counsel has reminded me, please just tell the jury what a drive test is.
The drive test is you use a device, this sort of like box that goes with you in the car when you physically drive by a cell phone tower. And that's how you can also confirm these azimuths and these latitude and longitude and stuff of the tower.
And you cannot testify to the accuracy of these actual CDR records you received. You're just relying on that data.
I rely on the data that T-Mobile provided, yeah.
Thank you so much, Ms. Ross. I don't have any other questions.
No regret, Judge.
All right, you can step down. Thank you.
Thank you, Your Honor.
Is she released from her subpoena?
Yes, Judge.
She is not, but she can leave.
She is not, but she can leave the courthouse?
Yes.
All right, thank you.
Your Honor.
All right, we will go ahead and take our lunch break at this time. Oh, I don't think you do have an attempted felony murder.
Yeah, it shouldn't be,
Yeah, I don't think I added it.
right, it's just attempted first degree premeditated.
So that's the only thing, right?
Yes.
Yes,
So then, no, those questions aren't necessary. All right. Because it's viewed as a felony applicable to count one.
Yes.
Yeah. All right, let me make these changes then. And we're ready. Your witness ready?
Yes, Judge.
Still no Shirley Bass?
Yes, Judge.
Okay, thank you.
All rise.
Jennifer Michael.
All right, have a seat. How was your lunch break? Great. All right. The weather's nice out there, huh? I wouldn't know. I didn't make it out, but I'll take your word. All right. The state can call your next witness.
The state calls Jennifer Michael on.
Raise your right hand, please. Do you solemnly swear or affirm that the testimony that you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, ma'am.
You come this way.
Good afternoon.
Good afternoon.
If you would please introduce yourself and spell your name for us.
My name is Jennifer Michelon, Jennifer, Michelon, Michelon.
Good afternoon.
Good afternoon.
Tell the jury, where do you work?
I work for the Hillsborough County Sheriff's Office in the firearms section of the Forensic Service Bureau.
How long have you worked with HDSO in the firearms section?
I've worked there for 2 years.
What's your title?
I'm a forensic laboratory firearms analyst.
I'm writing that down so I don't get it wrong. Forensic laboratory firearms analyst. What does a forensic laboratory firearms analyst do?
My main duties are to determine whether or not ammunition components, such as a fired bullet or a fired cartridge case, were fired in the same firearm or from a specific firearm, firearm function and safety testing, serial number restoration, and database entry.
Before you started at HDSO, did you work elsewhere also with firearms?
Yes, I did.
Where did you work?
I worked for the Florida Department of Law Enforcement in the firearms section of the Tampa Crime Lab.
What was your title when you worked for the Florida Department of Law Enforcement? We also call it FDLE in the firearms department.
My title when I left was Senior Crime Laboratory Analyst.
What did you do at Florida Department of Law Enforcement as a senior crime laboratory analyst?
I did the same thing that I'm doing at Hillsborough County Sheriff's Office.
So let's go back to your education and your background in firearms. Tell the jury what your training and your education background is in firearms.
I have a bachelor's degree in chemistry from the University of South Florida, and I completed an 18-month structured training program at the Florida Department of Law Enforcement in the field of firearms identification.
What year did you start working at FDLE?
I began working at FDLE in 2006.
When you started working with FDLE in 2006, did you receive specialized training in order to become a crime laboratory analyst?
When I began with FDLE in 2006, I was in a different section. I started in firearms in 2009.
So in 2009 at FDLE, explain to us what training that you underwent in order to be working in the firearms section at FDLE.
The 18-month structured training program that I went through included units in firearms function and safety testing, which included assembly and disassembly of firearms in order to know how they work. I did units in microscopy of bullets, microscopy of cartridge cases, firearms history and development, ammunition history and development. I did units in serial number restoration, distance determination, and I also completed then I completed an oral board, which was essentially 3.5 hours of question after question, making sure I understood everything in the firearms section. During that time, I also completed I had to do competency tests and also had to do practicals in order to be able to complete my training. After I completed all of that, I did 6 months of supervised casework, which was then culminated with a mock trial of testimony, and then I was released to do supervised casework. I'm not supervised, my own casework.
Do you have to have an official certification in order to be completely done with all of this training to do your own casework?
I received just a completion of the training program from the Florida Department of Law Enforcement.
When you worked at FDLE in the forensic or the firearms department, approximately how many times did you have an occasion to analyze a firearm?
I did not count how many times I had an opportunity to analyze a firearm, but at this point it's in the thousands.
When you started at HDSO, approximately how many times since you've joined HDSO have you had an occasion to analyze a firearm?
Hundreds.
Have you testified in court as a firearms expert before?
Yes, I have.
Approximately how many times?
More than 60.
Your Honor, at this time, I tender the witness as an expert in the area of firearms to.
Any questions?
No question.
All right, you can proceed.
Help us understand, we have, during the course of this trial, heard terms such as projectile and casing. Are those things that you analyze in your capacity as a forensic lab firearms analyst at HCSO?
Yes.
Let's start with a projectile. Walk us through, what is a projectile?
A projectile is the portion, it is also called a bullet, that is the part of a cartridge that will go down the barrel of a firearm when it is fired.
What about a casing? What is a casing?
A cartridge case is the Tupperware container of the cartridge itself. It will hold the bullet at the top. The cartridge case holds inside of it the gunpowder, and at the very head stamp or the bottom of the cartridge case, you will see the primer. On the head stamp of that cartridge case is usually the brand and the caliber.
So a projectile, is that word synonymous with or the same as a bullet in layman's terms?
Yes.
You refer to the cartridge casing. We've heard the term casing. Are those two words or terms synonymous, the same thing?
Yes, I call it a cartridge case. I will hear the word casing.
Now, when you are analyzing a firearm, what is the purpose of analyzing a firearm?
When I'm looking at a firearm, I'm looking at it to see that all of the safeties are working, that there's no damage to the firearm. I want to make sure it's safe for me to fire when the time comes. Then the next step would be to test fire that firearm and obtain those test fires in order to look at those test fires to do any comparisons to any evidence of cartridge cases or bullets that I might receive.
When you receive a firearm and you are requested to test a firearm, when you're doing these test fires, is that the process of making sure the firearm is functional?
Yes.
During your inspection of the safeties that you described, is that also a part of your analysis of whether or not a firearm is actually functional?
Yes.
When you analyze a firearm to see if the safeties are working or whether or not it's functional, do you ever receive projectiles or cartridge casings as well?
Yes.
What are you an expert at doing when you have a projectile, casings, and a firearm as a forensic lab firearms analyst?
I am tasked to determine whether or not those bullets or cartridge cases were fired in or from that firearm.
I want to talk about that process in detail. When you are tasked with analyzing whether or not a cartridge casing came from a specific firearm, walk us through the process. How is that done?
Once I've test fired the firearm, I'm going to bring those test fires back, and I'm going to then look at the class characteristics that are on those cartridge cases. I'm going to document them on the firearm worksheet, and then I'm going to take out each of the evidence cartridge cases that I receive, and I'm going to document each one of those. I'm going to look to see what the class characteristics are on that particular cartridge case. So a class characteristic is something that's predetermined by the manufacturer, and it could be typical of other guns, not just that particular gun. An example would be the shape of the firing pin, the shape of the firing pin aperture, that's the hole that the firing pin sticks out of, and what type of marks I see on that cartridge case. In order for me to do that, I use a comparison microscope, which allows me to see two things at the same time at the same magnification. Now, if those class characteristics on the cartridge cases are the same class characteristics that I see on the firearm, I can then begin another part of the examination, which is called looking for the individual characteristics or the pattern of individual characteristics. The pattern of individual characteristics is unique to that firearm, and it's caused by the manufacturing process itself, and it also can come from the use, abuse, erosion, corrosion of the firearm. So when I'm looking, I want to see if those individual characteristics that I see on the cartridge case are the same individual characteristics that are on the test fire or the other cartridge cases that I've received.
That was a lot of information. Let's go back. Class characteristics. When you are test firing a firearm and, for instance, looking at the casing that comes out during the test fire, help us understand how do those class characteristics get there?
So when the firearm is fired, the cartridge case, the first thing that's going to happen is the firing pin is going to strike that primer, and it's going to leave an impression of the shape of that firing pin on the primer of the cartridge case.
If I can stop you right there, I apologize. You've used the term firing pin and primer.
Yes.
What are those, and where are they located within a firearm?
The firing pin is located inside the slide, in the center of the slide, back portion of it, in the firearm. It's the portion that will be released forward when you are ready to fire the firearm. And a primer is that circle that you see on the back of a cartridge case, and that is where the spark comes from on a cartridge.
Okay, so the firing pin and the primer, you were explaining the process of how those class characteristics get on the actual casing that is expelled. Please continue, I'm sorry.
So the firing pin will make an impression onto that primer, which will then cause an explosion. The light that, or I'm sorry, the spark that comes from the primer will ignite the gunpowder that's inside the cartridge, which in turn will make the bullet go down the barrel, but it will also force that cartridge case back against the back portion of the slide, and it will also leave marks in the on the back or the primer of that cartridge case. At that point, then the cartridge case gets expelled from the firearm.
Now, what about individual characteristics? You said the individual characteristics that are left on the cartridge casing differ. They're not the same.
From firearm to firearm.
Okay, so let's talk about a projectile, for instance. What happens to a projectile as it's going through to be ejected or fired from a firearm?
When the cartridge is ignited and the bullet goes down the barrel, the bullet will travel down the barrel and it will get class characteristics from inside the barrel, which are the rifling inside the barrel, which are those spiral grooves that you see within the interior of the barrel. Those will be imparted onto the bullet. That's a class characteristic. Multiple firearms may have the same class characteristics. At that same time, it's also getting individual characteristics imparted onto it.
Those impressions or class characteristics and individual characteristics, is that what allows you to analyze a test fire to a projectile that's already been fired to see whether or not they match?
Yes.
Before you kind of started to describe using a microscope to compare the two, the test fire that happens in a controlled environment and the one that's actually expelled. Help us understand how you do that.
The first thing I do is I want to make sure each of those items has individual characteristics. I can't continue my examination if it does not have any individual characteristics. If it does have individual characteristics, I can compare the item of evidence to a test fire or to other items of evidence.
In this case, tell the jury, so what happens next?
If I see repeating patterns of individual characteristics on the item, then I can make identifications.
And again, you're looking at these class characteristics and individual characteristics on a test fire and a projectile provided to you under a microscope, correct?
Correct.
Now, tell us about the test firing process. When you receive a firearm and you're requested to test fire it, where do you do that?
I test fire it into the section water tank.
What does the water tank look like?
The water tank is essentially a big steel box that has a port on one end, and you'll fire the firearm into that port.
Is it just like a big open area that you aim at and fire in, or is it a defined area?
There is a small port at the front of the tank. The tank is filled with water. I aim the firearm into that port, and then the bullets will be collected from the water.
How many times do you think in your career as a firearms analyst have you done this process of firing a firearm into this water tank with this port at the front?
I haven't counted, but I would assume at this point in the thousands.
When you're test firing firearms, are they all of the same type or are they different types?
As far as the cartridge?
No, of the firearms that you're asked to fire.
I have test fired many different firearms.
Have you test fired a Glock 43 as the same as the one that was involved in this case and provided to you?
43 or 42?
42.
Yes, I have.
And for reference, I'll show you what's been entered into evidence as State Exhibit 16. I'm going to place it in front of you. Were you provided State's Exhibit, was it 16? 16 to test fire.
May I check the box? Yes, I was.
How do you know?
I could see the case number, the exhibit number, and my initials in my handwriting on the firearm and the magazine.
Each firearm that you receive for testing, does it get an individual case number associated with it that you just explained is representative on this firearm?
It gets an individual property item number or exhibit number, and it will have a case number, and then I will write those things on the firearm or the date and my initials on them. In this case, I wrote all of that myself.
When you receive a firearm, I heard you talk about some of your training includes the assembly and disassembly of the firearm when deciding whether or not a firearm is operable. Is that correct?
Yes.
Did you do that in this case? Is that a part of your evaluation when you receive a firearm, is assembling and disassembling, disassembling and then assembling the firearm?
I test fired the firearm first, and then I did remove the slide to check the safeties.
Okay, so how many occasions have you had in your career to fire a Glock 42 specifically?
I don't have a specific number. I've fired many Glocks, though.
Do you think over 100 times in your career is safe to say, approximately?
Yes.
Now, let's talk about your understanding and your education or background in the brand of Glock. What do you know about the brand of Glock?
I did take a Glock armorer's course when I began my training at the Florida Department of Law Enforcement, and I'm very aware of how the Glock operates.
Tell us how the Glock operates. And I guess while you're explaining that, can you specify how it operates and how it may be different than other brands?
Do you want me to start with how to essentially fire the Glock?
Sure.
In order to test fire or to fire a Glock, the first thing you need to do is to load ammunition into the magazine. That's the container that holds the cartridges so that you can fire one right after the other. The next thing you're going to need to do is take that top portion of the firearm and you're going to have to pull the slide back and release it. I'm sorry, after you've inserted the magazine into the mag well. Then you're going to take that slide back and release it. The first cartridge in that magazine will now be inserted into the chamber of the firearm and the firearm is ready to fire. When you released that slide at the top of the firearm, at that same time, the firing pin has been slightly cocked in the firearm. That means it's been pulled back ever so slightly. Now the firearm is ready to fire. When I pull the trigger, I have to depress the trigger itself, and there's also a trigger safety on this particular firearm. I have to depress the trigger safety and the trigger at the same time in order for that firearm to fire. When I pull that trigger, the firearm will fire, the bullet will go down the barrel, the slide will move back, and the cartridge case will be extracted and ejected from the firearm. At the same time, the slide will now start moving back forward. It will take the next cartridge out of the magazine, and it will load it into the chamber. And it will have now repeated the process that happened again.
On the Glock brand specifically, help us understand the safety precautions that are present on Glock firearms.
The Glock has the trigger safety, which is located on the trigger. It's in the center. It kind of protrudes a little bit from the trigger itself. It's right down the middle. You have to depress it in order for the trigger to be pulled back. The Glock also has a firing pin block safety, which in order for that firing pin block to get out of the way of the firing pin, you have to pull the trigger. And again, in order to pull the trigger, you have to depress the trigger safety. This firearm also has what is known as a drop safety. All that particular thing is doing is it's holding back that firing pin, and then it will pull it back a little bit more and then drop out of the way. And the firearm will not fire unless that has dropped out of the way.
So, for instance, with this firing pin block safety, does that help prevent things like accidental shootings?
The firing pin block safety will not allow the firing pin to go forward unless the trigger has been pulled.
The trigger safety you've described as a small object on the middle of the trigger. If the trigger safety is depressed, but not the entire trigger behind it, will a Glock 42 fire?
If just the safety has been depressed, no, it will not fire. You have to finish pulling the trigger.
Help us understand the difference of the terms semi-automatic firearm and automatic firearm.
A semi-automatic firearm requires a pull of the trigger for every shot that is fired. A fully automatic firearm, all you have to do is depress the trigger, and as long as there is ammunition in the magazine and you're still depressing that trigger, it will continue to fire.
The Glock 42 that we see in Space 16 that's sitting on the ledge in front of you, is that a semi-automatic firearm or is that an automatic firearm?
It's a semi-automatic firearm.
Does that mean in order for the firearm to be fired multiple times, you would have to both depress the trigger safety and the trigger in its entirety multiple times in order to fire it?
Correct.
Asked in another way, does it require you to completely pull and then release it before pulling it again to continue firing it?
You will pull, and then you have to release pressure. It doesn't mean your finger's still not there. It may be putting a little pressure, but it does have to be fully extended again in order for you to pull again.
If a Glock 42 with these safety features, which you've described on the Glock 42 in front of you, were to, for instance, be dropped, would it be able to go off?
With the firing pin block safety, it would not go off.
I want to talk about the process of test firing again. You described to us the water tank that you fire into. Using your hands, can you raise your hands up and show the jury exactly how big is that, I forget what you called it, the port that you fire into?
It's approximately 6 inches wide.
Approximately 6 inches wide. And is that standard for you? You've done that in every case where you fired firearms into this water tank?
Not every firearm will get fired into the water tank, but most do.
Okay, so when you test fired this firearm into a water tank that had a 6-inch wide port, how many hands did it require you to use on the firearm to point and aim it correctly in the hole?
I used two.
Question relevance?
Overruled.
You can answer it.
I use 2 hands.
Why did you use 2 hands?
I want to make sure I'm holding the firearm firmly so it will cycle properly.
We sometimes hear in conjunction with firearms terms such as recoil. What is recoil?
Recoil is the amount of force that's going to come back at you after you have test fired a firearm or fired a firearm. It causes a little bit of force into your hand.
A Glock 42, or I guess maybe even the Glock brand in general, what is the recoil based on your training and your experience firing Glocks? What is the recoil like in firearms?
Depends on the firearm. For Glock, I do have some recoil when I'm firing the firearm. It's not the same as other firearms.
Does the recoil depend on the caliber and type of firearm?
It can.
So when you're holding a firearm and you're firing, for instance, into your water tank, or you're trying to aim, how do you combat the recoil that you would experience of the firearm after, or as it's fired, excuse me?
I am using 2 hands when I test fire, and then I just wait in between shots to make sure I can aim and make sure I am aimed properly into the port.
May I have just a moment, Judge?
Yes.
In this case, were you provided shell casings and projectiles in order to do a comparison after you test fired the firearm?
Yes.
Tell us about that process.
I received bullets and cartridge cases in this case, and I obtained them from the evidence section, and then I brought them back in order to compare them to my test fires of this firearm.
How many test fires did you have when you test fired this firearm?
I test fired this firearm twice.
How many do you use how many of the test fires do you use when you're placing it on the microscope and you're looking at it in comparison to the ones that you're provided from the scene?
I used 1 bullet, 1 cartridge case.
Is that standard?
You could use multiple test fires if needed, or multiple bullets or cartridge cases. It depends on the scenario.
Did you need to do that in this case?
In this particular case, I did not.
Why?
They were well marked.
Okay, so you test fire it, you have a test casing and a test projectile. How many projectiles did you receive either from the scene or from the deceased?
I received 3 fired bullets and 1 fired bullet core.
Did you compare those bullets to your test fire?
I compared the fired bullets to each other and to the test fire.
What's the purpose of comparing the fired bullets to each other?
I had originally, when I was going through to see the individual characteristics, I noticed that they all had the same individual characteristics, and I could see marks that looked similar on each of them as I put each one up individually, and then I put them up together to just index them or mark them to see those patterns were the same at that point.
After you compared the test fires to each other, did you choose one and compare it to each projectile or bullet that you were provided in this case?
In this particular case, I compared the bullets to each other first, and I took one of them and I compared it to a test fire.
Why do you compare the bullets provided to you from the scene or the deceased to each other first?
In this particular case, there was no reason why I did that over looking at them to the test fire. It's just I had seen the pattern when I was looking at them individually, so I marked them at the time.
What is your expert opinion about the projectiles that you were provided associated with this case that you received from either the scene or the deceased?
I identified them to the firearm.
And are you talking the firearm in front of you, State's Exhibit 16?
Yes.
Does that mean that the projectiles that you were provided and used during your analysis came from State's Exhibit 16, the Glock 42 that's in front of you?
Yes.
What about the cartridge casings? Were you provided cartridge casings and asked to compare them in this case?
Yes.
How did you do that?
I took those cartridge cases, I looked at them each individually and made sure they had individual characteristics, and then I compared them. In this particular instance, I compared each cartridge case to a test fire.
When you compared each cartridge case that was found at the scene of this event to the test fire, tell the jury what your results were.
I determined that they were identified to the firearm here in front of me.
Does that mean that those cartridge casings were expelled from the firearm that's sitting in front of you?
Yes.
Judge, may I have just a moment?
Yes.
If I don't have any further questions, I will take just one moment to return.
Cross?
Good afternoon.
Good afternoon.
Now, you were involved in doing some analysis in this case, and then later on, you were asked to do some additional analysis more recently.
That is correct.
And that was based on the retirement of one of the FDLE examiners that was involved in the case, Mr. Kwong.
That's what I'm assuming, yes.
Okay. But you had originally done some test fires in the case and did an examination of the firearm.
That is correct.
So then later, when you were asked to continue to review the case or review the rest of the evidence, you were able to use those original test fires that you used in this case.
That is correct.
And you were able to identify those casings to each other and to the firearm in this case.
In this particular case, I ID'd each cartridge case back to a test fire.
Okay. And that test fire was from this firearm that you were shown a minute ago.
Yes.
When you looked at the ammunition, there was two types of ammunition, right, from the casings?
Correct.
And what were the types of ammunition?
There were two types, Hornady and Norma.
Okay. And both of those are obviously .380.
Correct.
Now, Ms. Reeder was asking you about the safety features on the Glock, on the firearm in this case, and you said that there's the trigger and the trigger safety, and then there's the firing pin block safety, correct?
There's the trigger safety, the firing pin block safety, and the drop safety.
Okay. And all of those, as you pull back the trigger, will go along and allow you to fire the gun.
That is correct.
It's not something that you have to do separately. It all kind of goes together as you pull the trigger.
Correct. As you're depressing the trigger along with that trigger safety, and you pull the trigger all the way back, it will release, I'm sorry, not release, but disengage the firing pin block safety, allowing that firing pin to flow through the channel.
Adults could fire this firearm, correct?
I would assume so.
Okay. And children could fire this type of firearm.
I can't determine whether or not anybody particularly could fire a firearm, but is it possible? Yes.
Okay. And in fact, you're able to test for trigger pull. Is that correct?
I do have a way of measuring trigger pull, yes.
But in this case, you did not do that.
No.
And that would tell you the force needed to pull the trigger with this particular firearm.
That is correct.
When you did do the test fires, you didn't find anything unique about this firearm versus any other kind of Glock that you've used before.
The trigger pull didn't seem any different than any other Glock that I fired.
And typically, you've stated that the trigger pull for a firearm is about like opening a can of soda.
Correct.
Nothing further.
Anything else?
No, Judge.
All right, you can step down, ma'am, thank you. All right, so both the state and the defense have rested their cases. As I warned you, now is my opportunity to instruct you on the law. As I also told you, you each have your own set of written instructions that have been just handed out to you, so you can use these. It's not a history test or a civics test. You don't have to remember everything I've said, so you'll have each of these copies to use during the arguments of the lawyers and or during deliberations as you should see fit. I am required by law, though, to read them aloud to you, so those of you who are visual learners are welcome to read along with me. Those of you who would like to be read to, maybe read to. Either way, I just ask you to pay attention to the instructions. All right, Jermaine Bass, the defendant in this case, has been accused of the crimes of first-degree murder and 2 counts of aggravated child abuse and 1 count of attempted first-degree murder. Here's some definitions that will apply throughout these instructions. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or any other object that was used or threatened to be used to inflict bodily harm. A deadly weapon or a dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. A firearm is any weapon which is designed to or may readily be converted to expel a projectile by the action of an explosive. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. Willfully means intentionally and purposely. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. In considering the evidence in this case, you should consider the possibility that although the evidence may not convince you the defendant committed the main crimes of which he is accused, there may be evidence he committed other acts that would constitute what's called a lesser included crime. Therefore, if you decide the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes included in the definition of first-degree murder are second-degree murder, third-degree felony murder, and manslaughter. The lesser crime included in the definition of aggravated child abuse is aggravated battery. The lesser crimes included in the definition of attempted first-degree murder are attempted second-degree murder and attempted manslaughter. Mr. Bass is accused of first-degree murder. First-degree murder includes the lesser crimes of second-degree murder, third-degree felony murder, and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Jaylah Bass was killed by Jermaine Bass, you will then consider the circumstances surrounding the killing and deciding if the killing was first-degree murder or any lesser included that should be offense, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances: when the killing is committed by accident and misfortune, in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent; or when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation; or when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. I'll now instruct you on the circumstances that must be proved before Jermaine Bass may be found guilty of first-degree premeditated murder or any lesser included crime. There are two ways a person may commit first-degree murder. One is known as first-degree premeditated murder, and the other is known as first-degree felony murder. To prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. 1, Jaylah Bass is dead. 2, the death was caused by the criminal act of Jermaine Bass. And 3, there was a premeditated killing of Jaylah Bass. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An issue in this case may be whether Jermaine Bass did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation. In order to find the defendant did not act with a premeditated intent to kill because he acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person. And a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. And there was not a reasonable amount of time for a reasonable person to cool off. And a reasonable person would not have cooled off before committing the act that caused death. And Jermaine Bass was, in fact, so provoked and did not cool off because he committed the act that caused the death of Jaylah Bass. If you have a reasonable doubt about whether the defendant acted with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, you should find him not guilty of the charge of first-degree premeditated murder. To prove the other way you can prove first-degree murder, first-degree felony murder, the state must prove the following three elements beyond a reasonable doubt. 1, Jaylah Bass is dead. 2, while engaged in the commission of an aggravated child abuse on either Jaylah Bass or Jermaine Bass in counts 2 and 3, or any lesser charge on those counts, Jermaine Bass caused the death of Jaylah Bass. Or, while engaged in the attempt to commit first-degree murder on Jermaine Bass in count 4, or any lesser charge, Jermaine Bass caused the death of Jaylah Bass. And 3, Jermaine Bass was the person who actually killed Jaylah Bass. In order to convict the defendant of first-degree felony murder, it is not necessary for the state to prove the defendant had a premeditated design or intent to kill. To prove the lesser included offense of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, Jaylah Bass is dead. 2, the death was caused by the criminal act of Jermaine Bass. And 3, there was an unlawful killing of Jaylah Bass by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose, and an act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. An issue in this case is whether Jermaine Bass did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation. And again, in order to find the defendant did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act that caused death, and Jermaine Bass was in fact so provoked and did not cool off before he committed the act that caused the death of Jaylah Bass. If you do have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, you should find him not guilty of the charge of second-degree murder. To prove the lesser crime of third-degree felony murder, the state must prove the following beyond a reasonable doubt. 1, Jaylah Bass is dead, and 2, her death occurred as a consequence of and while Jermaine LaVonda Bass was engaged in the commission of the felony lesser offense of aggravated battery, and Jermaine Bass is the person who actually killed Jaylah Bass. In order to convict of third-degree felony murder, it is not necessary for the state to prove the defendant had a premeditated design or intent to kill. The lesser offense of aggravated battery for the purpose of this instruction is defined in Instruction 8.4 in the following instructions. See also Instruction 3.12D, interlocking counts, that we'll get to in a minute as it pertains to this lesser offense. To prove the lesser included offense in count 1 of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, Jaylah Bass is dead. 2, Jermaine LaVonda Bass intentionally committed an act or acts that caused the death of Jaylah Bass, or the death of Jaylah Bass was caused by the culpable negligence of Jermaine Bass. Every person has a duty to act reasonably toward others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which did cause death. I'll now define culpable negligence for you. As I've said, every person has a duty to act reasonably toward others, and a violation of that duty without conscious intention to harm is negligence. But culpable negligence is more than a failure to use ordinary care toward others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. To prove the crime of aggravated child abuse for counts 2 and 3, the state must prove the following 2 elements beyond a reasonable doubt. 1, Jermaine Bass committed an aggravated battery upon Jaylah Bass in count 2, or Jermaine Bass for count 3. And 2, Jaylah Bass in count 2, or Jermaine Bass in count 3, was under the age of 18 years. In order to prove that an aggravated battery was committed, the state must prove the following 2 elements. The first element is a definition of battery. 1, Jermaine Bass actually and intentionally caused bodily harm to Jaylah Bass in count 2, or Jermaine Bass in count 3. And 2, in doing so, Jermaine Bass intentionally or knowingly caused great bodily harm. It is not a crime for a parent of a child to impose reasonable physical discipline on a child for misbehavior under the circumstances, even though physical injury resulted from the discipline. To prove the lesser included crime of aggravated battery for counts 2 and 3, the state must prove the following 2 elements beyond a reasonable doubt. And the first element is a definition of battery. 1, Jermaine Bass intentionally caused bodily harm to Jaylah Bass in count 2, or Jermaine Bass in count 3. And 2, Jermaine Bass in committing the battery intentionally or knowingly caused great bodily harm to the victim. For count 4, in order, Jermaine Bass is accused of attempted first-degree murder. Attempted first-degree murder includes the lesser crime of attempted second-degree murder and attempted manslaughter, all of which are forms of attempted homicide, and all of which are unlawful. However, an attempted homicide that was excusable or was committed by the justifiable use of deadly force is lawful. If you find there was an attempted homicide of Jermaine Bass by Jermaine LaVonda Bass, you will then consider the circumstances surrounding the attempted homicide in deciding whether it was attempted first-degree murder or attempted second-degree murder or attempted manslaughter, or whether the attempted homicide was excusable or resulted from the justifiable use of deadly force. An attempted homicide is justifiable and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. An attempted homicide is excusable and therefore lawful under any one of the following three circumstances. When the attempted homicide is committed by accident and misfortune and doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or when the attempted homicide occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or when the attempted homicide is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the attempted killing is not done in a cruel or unusual manner. I'll now instruct you on the circumstances that must be proved before Jermaine LaVonda Bass may be found guilty of attempted first-degree murder or attempted second-degree murder or attempted manslaughter by act. To prove the crime of attempted first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. 1, Jermaine LaVonda Bass intended to commit the crime of first-degree premeditated murder. And 2, he committed an overt act toward the commission of first-degree premeditated murder that went beyond mere preparation. And 3, Jermaine Bass failed to complete the first-degree premeditated murder. The line between mere preparation and an overt act is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime. An overt act consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward completing the crime. To prove that a first-degree premeditated murder had taken place, the state would have had to prove the following three elements beyond a reasonable doubt. 1, Jermaine Bass is dead. 2, the death was caused by the criminal act of Jermaine LaVonda Bass. And 3, there was a premeditated killing of Jermaine Bass. To prove the crime of attempted second-degree murder, a lesser included offense of count 4, the state must prove the following three elements beyond a reasonable doubt. 1, Jermaine LaVonda Bass intentionally committed an overt act that could have resulted in the death of Jermaine Bass, but did not result in Jermaine Bass's death. And 2, that act was eminently dangerous to another and demonstrating a depraved mind without regard for human life. And 3, the overt act went beyond mere preparation. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself indicates an indifference to human life. The line between mere preparation and overt act, again, is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime. An overt act consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward completing the crime. To convict the defendant of attempted second-degree murder, it is not necessary for the state to prove the defendant had any intent to cause death. To prove the lesser included crime in count 4 of attempted manslaughter by act, the state must prove the following two elements beyond a reasonable doubt. Jermaine LaVonda Bass intentionally committed an overt act that could have resulted in the death of Jermaine Bass, but did not result in Jermaine Bass's death. And 2, the overt act went beyond mere preparation. And again, the line between mere preparation and overt act is a question of fact for you to decide, and we've defined that before 2 times already. The defendant cannot be guilty of attempted manslaughter by act by committing a merely negligent act. Again, every person has a duty to act reasonably and use ordinary caution toward others. If there is a violation of that duty without any conscious intention to harm, that violation would be negligence. To convict of attempted manslaughter by act, it is not necessary for the state to prove the defendant had an intent to cause death, only an intent to commit an act that could have caused death and was not justifiable or excusable attempted homicide, as I previously instructed you. If you do find Jermaine LaVonda Bass committed first-degree murder, second-degree murder, third-degree felony murder, or manslaughter, or attempted first-degree murder, attempted second-degree murder, or attempted manslaughter, you will then be asked to determine whether the state has proven beyond a reasonable doubt he personally carried, displayed, used, threatened to use, or attempted to use any weapon or firearm. If you find he committed first-degree murder or second-degree murder, third-degree felony murder, attempted first-degree murder, attempted second-degree murder, or aggravated child abuse, you will also be asked to determine whether the state proved beyond a reasonable doubt that during the commission of that offense, he actually possessed a firearm, whether he discharged that firearm, and whether that discharge caused death or great bodily harm. To actually possess a firearm means the defendant carried a firearm on his person or had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. Mr. Bass has entered a plea of not guilty. This means you must presume or believe he is innocent. This presumption of innocence stays with him as to each material allegation in the charging document through each stage of this trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome his presumption of innocence, the state has the burden of proving the crime with which he is charged was committed and that he is the person who committed that crime. Mr. Bass is not required to present evidence or to prove anything. Wherever the phrase reasonable doubt is used, you must consider the following. A reasonable doubt is not a mere possible doubt or a speculative, imaginary, or a forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of his guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction of his guilt, or if you have a conviction of his guilt, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find him not guilty because that doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you're to look for that proof. A reasonable doubt as to the guilt of Jermaine Bass may arise from the evidence, from conflicts in the evidence, or from a lack of evidence. If you have a reasonable doubt, you should find him not guilty. If you have no reasonable doubt, then you should find him guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are as follows. Did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Did the witness's testimony agree with other testimony and other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in the courtroom? The evidence that a witness may have made a prior statement that is inconsistent with his or her testimony in court should be considered only for the purpose of weighing the credibility of that witness's testimony and should not be considered as evidence or proof of the truth of the prior statement or for any other purpose. Had the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The fact that a witness is employed in law enforcement does not mean his or her testimony deserves more or less consideration than that of any other witness. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. Whether the state has met its burden of proof does not depend on the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of evidence presented. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against Jermaine Bass. It is not necessary for him to disprove anything, nor is he required to prove his innocence. It is up to the state to prove his guilt by evidence. Mr. Bass has exercised a fundamental right by choosing not to be a witness. You must not view this as an admission of guilt or be influenced in any way by this decision. No juror should ever be concerned that he did or did not testify at trial. Statements claimed to have been made by Jermaine Bass outside of court were testified to in this trial. Any such statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence whether the alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to, whether when he made the statement he had been threatened in order to get him to make it, and whether anyone had promised him anything in order to get him to make it. If you conclude that any out-of-court statement was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. First, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict would be a miscarriage of justice. There's no reason for failing to follow the law. Everyone is depending upon you to make a wise and legal decision in this case. This case must be decided only on the evidence you've heard from the testimony of the witnesses, have seen in the form of exhibits and evidence, and based on these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or because you are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in any way. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is then my responsibility to determine a proper sentence if he is indeed found guilty. Whatever verdict you render must be unanimous, which means each juror must agree to the same verdict. In reaching your verdict, do not let bias, sympathy, prejudice, public opinion, or any other sentiment for or against any party influence your decision in any way. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your responsibility. I cannot participate in that decision in any way. So please disregard anything I may have said or done or any ruling that I've made that make you think I prefer one verdict over another. You may find Mr. Bass guilty as charged in the charging document or guilty of such lesser offense as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count, which was proved beyond a reasonable doubt. If you find no offense was proved beyond a reasonable doubt, then of course your verdict must be not guilty. If you do return a verdict of guilty to the charge of first-degree murder, it is not necessary that all of you agree the state proved first-degree premeditated murder, and it is not necessary all of you agree the state proved first-degree felony murder. Instead, what is required is that all of you agree the state proved either first-degree felony murder or first-degree premeditated murder. You will be asked to choose as to each theory of first-degree murder whether or not you are unanimous as to that theory. A separate crime is charged in each count of this charging document, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one count must not necessarily affect your verdict as to any other count charged, except as follows. Legally interlocking counts, and this describes the first-degree felony murder count in count 1 and counts 2, 3, and 4. So first-degree felony murder in count 1 and aggravated child abuse in counts 2 and 3, or attempted first-degree murder or attempted second-degree murder in count 4, are linked in that the aggravated child abuse or the attempted first-degree or attempted second-degree murder is an essential element of first-degree felony murder. So you should consider the evidence applicable to the aggravated child abuse charge and the attempted first-degree and attempted second-degree murder charge. If you find that the aggravated child abuse charge or the attempted first or second degree murder charge has not been proved beyond a reasonable doubt, then you must find Jermaine Bass not guilty under the theory of first degree felony murder in count 1. But you can still consider whether first degree murder under the theory of premeditation or a lesser offense of second degree murder or of manslaughter have still been proven beyond a reasonable doubt as to count 1, and if so, return a verdict of guilty for that offense. If, on the other hand, you do find aggravated child abuse charge or the attempted first or attempted second degree murder has been proved beyond any reasonable doubt, you can there and must then consider the evidence applicable to the theory of first degree felony murder. A guilty verdict for aggravated child abuse or for attempted first degree or attempted second degree murder does not require a guilty verdict under the theory of first degree felony murder. You may find him guilty under the theory of first-degree felony murder only if you find all the elements of that crime, including the essential elements of aggravated child abuse or of attempted first-degree or second-degree murder, were proved beyond a reasonable doubt. Additionally, count 1 lesser offense of third-degree felony murder and count 2 and 3 lesser offense of aggravated battery are also linked, and that the aggravated battery in count 2 and 3 are linked to as being an essential element of third-degree felony murder in count 1. So, you should first consider the evidence applicable to the lesser offense of aggravated battery. If you find the aggravated battery has not been proved beyond a reasonable doubt, then you cannot find him guilty of third-degree felony murder. But you may consider whether different lesser offenses of second-degree murder or of manslaughter have still been proven beyond a reasonable doubt, and if so, return a guilty verdict for that lesser offense. If, on the other hand, you find that the lesser offense of aggravated battery has been proved beyond a reasonable doubt, you must then consider the evidence applicable to the third-degree felony murder. A guilty verdict for aggravated battery does not require a guilty verdict for third-degree felony murder in count 1. You may find them guilty of third-degree felony murder, that lesser offense in count 1, only if you find all the elements of that crime, including the essential elements of aggravated battery, were proved beyond a reasonable doubt. Only one verdict may be returned as to each count, and each of you must agree to the same verdict. The verdict must also be in writing, and for your convenience, we prepared the verdict form for you. And if you'll flip over to page 20, we're going to go over that together just so there are no questions. You'll see on page 20, we, the jury, find as follows as to count 1, murder in the first degree. You check only one letter, A, B, C, D, or E, and answer any questions under the lettered selection. So A, the defendant is guilty of murder in the first degree of Jaylah Bass as charged. And if you select A, you must answer each of these following questions. 1, did the defendant personally carry, display, use, threaten, or attempted to use any weapon or firearm? Yes or no? Did the defendant actually possess a firearm? Yes or no? Did the defendant discharge the firearm? Yes or no? Did the discharge cause the death of the victim? Yes or no? 5, you must fill in a number. Blank of the 12 of us find the killing was premeditated murder. 6, blank of the 12 of us find the killing was felony murder based upon a guilty verdict of aggravated child abuse on counts 2 and 3, or a guilty verdict of any degree of attempted homicide on count 4. And 7, blank of the 12 of us find the killing was premeditated murder and felony murder. Or B, the defendant is guilty of the lesser offense of murder in the second degree, a lesser included offense. If you select B, you must answer those first 4 questions, either yes or no. Or C, the defendant is guilty of felony murder in the third degree, a lesser included offense. If you select C, you have those first 4 questions to again answer yes or no. Or D, the defendant is guilty of manslaughter, a lesser included offense. And if so, you answer that first question, yes or no. Or E, the defendant is not guilty. For counts 2 and 3, those are the same. We, jury, find as follows as to count 2. That's the aggravated child abuse of Jaylah Bass. A, the defendant is guilty of aggravated child abuse as charged. B, the defendant is guilty of aggravated battery, great bodily harm, a lesser included offense. Or C, the defendant is not guilty. Those same 3 findings under we, the jury, find as follows as to count 3, the aggravated child abuse of Jermaine or JJ Bass. And on the last page, page 22, we, the jury, find as follows as to count 4. That's the attempted murder in the first degree of Jermaine J.J. Bass. Again, you answer only one letter, A, B, C, or D. If you select any of those letters, if there are questions under them, you must answer each one yes or no. A, the defendant is guilty of attempted murder in the first degree of Jermaine J.J. Bass as charged. You must answer 1, did the defendant personally carry, display, use, threaten, or attempted to use a weapon or firearm? Yes or no? Did the defendant actually possess a firearm? Yes or no? Did the defendant discharge the firearm? Yes or no? Did the discharge cause great bodily harm to the victim? I see I left out the yes or no, so I'll add that before I finalize this verdict form. And then B, attempted murder in the second degree, a lesser included offense, those same 4 questions to answer. C, the defendant is guilty of manslaughter, a lesser included offense, that first question to answer. And or D, the defendant is not guilty. There's also a place for the foreperson to both sign and print his or her name and date the verdict form. So at this time, I'm going to turn it over to the lawyers to give their final arguments to you. I'm just going to remind you of a couple of things. 1, the lawyers are not witnesses, so what they say is not testimonial evidence. So if their recitation of the facts differs from your recollection of the facts, I'm going to ask you to rely on your own memories. That's why you've been chosen as jurors in the first place. Both sides have equal time to address you, but because the state has the burden of proof, they're entitled to go both first and last in their remarks to you. The state prepared to make a final argument.
Yes, Judge, but maybe we approach first real quick.
Sure.
One of the girls, or one of them.
Yeah.
Members of the jury, we end right where we began. It was an accidental discharge. I was trying to take the magazine out, and it went off. They was both in bed. I was in their room. Those were the statements of the defendant, Jermaine Bass Jr. Mere minutes after he murdered his daughter while she was laying in the top bunk of her bed. Those were his statements as he was holding his son, who was profusely bleeding from a gunshot wound to the side of his head that he caused. It was an accident. I was loading the magazine. I was in their room. Those statements you heard on the body-worn camera of Adam Rahman, that HCSO deputy who first responded. I want to draw your attention on that same body-worn camera to the timestamp of 22:46:20, right after he made these statements. The defendant was asked, "What happened upstairs?" He looked straight at the deputies and he said, "Nothing happened upstairs." That man uttered those words, "Nothing happened upstairs," when he knew that his daughter was on that top bunk with a gunshot wound to the middle of her forehead, and she was bleeding out and she was about to die. He said, "Nothing happened upstairs." He didn't beg them to go save her. He didn't beg them to help her. He said, "Nothing happened upstairs." We end right where we began. Right where we began. Where defense counsel in their opening statement to you said, "My client did not shoot Jaylah Bass or JJ." We know that's not true. We know he did it. We know that forensic evidence points to him. And I want you to recall when our blood spatter expert was on the stand. She said to you, "The scene will guide you to collect the evidence that is relevant so that you can piece together what happened." And members of the jury, that's exactly what happened throughout the duration of this trial. The testimony and evidence are pieces that, when laid together, form an arrow that point to the guilt of only one person in this case. The defendant murdered his 5-year-old daughter as she was sleeping, and he tried to murder his 8-year-old son, JJ. Remember this last Friday during jury selection, you were taught that the state has the burden to prove the elements of the crimes charged beyond a reasonable doubt. The judge explained that to you, and in fact, she just read it in this packet. It helps to know what the elements are, what we're focusing on as we go through discussing how and why we know the defendant is guilty of each element of each crime charged in this case. We'll go one by one. First-degree premeditated murder. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. Jaylah Bass is dead. Number 2, the death was caused by the criminal act of Jermaine Bass. And number 3, there was a premeditated killing of Jaylah Bass. He's also charged with 2 counts of aggravated child abuse. There we talk about number 1, Jermaine Bass committed aggravated battery upon Jaylah Bass or Jermaine Bass. That's counts 2 and 3. Jaylah Bass or Jermaine Bass were under the age of 18. We know that. Jermaine Bass actually and intentionally caused bodily harm to Jaylah Bass or Jermaine Bass, counts 2 and 3. In doing so, Jermaine Bass intentionally or knowingly caused great bodily harm. We know that as well. You saw the gunshot wounds. The last count he's charged with is count 4, premeditated murder. Jermaine Bass intended to commit the crime of first-degree premeditated murder. Number 2, Jermaine Bass committed an overt act toward the commission of first-degree premeditated murder that went beyond mere preparation. Number 3, Jermaine Bass failed to complete the first-degree premeditated murder. Let's talk about how and why we know the defendant is the one who pulled the trigger. And let's talk about how and why we know that he did it intentionally. We know that the defendant started out his night by leaving his 5-year-old and his 7-year-old home alone in their beds. We know that's true. 5 and 7, home alone at nighttime. We know that he followed his wife Shirley to her family dinner in the West Shore area at Ruth's Chris restaurant. How do we know that? State Exhibit 21. We can track his cell phone records. He leaves the children home alone by at least 7:15 p.m. We know that's true because of the video surveillance shows him leaving before that time. We know that Shirley got to dinner and that the defendant arrived in the West Shore area where Ruth's Chris is located. And around 10 o'clock, we know that he's calling Shirley and he's leaving by 10:01. We heard testimony from Shirley's niece, who's kind of more like a cousin or similar in age, China Gadsden. She explained to you what she saw that night. She saw the defendant and his Nissan truck pull in front of Shirley's car that she was driving, stop, get out, walk up to the vehicle, and confront Shirley for going to a family dinner. You know, he immediately got back in his car and went to his house. That's what State 21 shows. Prove his phone records. We know that's true. Just like Anna Cox said, the evidence will reveal to you what happened. Other evidence that reveals this in fact is true, that the defendant followed Shirley to her dinner and confronted her. It's the IM crime camera video footage that we see of the defendant's car. We can read between the lines of the evidence we have as to the way the defendant was feeling at the time he arrived back home and went inside where 5-year-old Jaylah Bass was sleeping in the top bunk. And 8-year-old Jermaine Bass, JJ, is laying right next to her. Now again, the scene will reveal itself. You only have to follow it. We know that the children were in the bed together. Laying side by side in the bed. I'm putting up States 24A because the forensic evidence tells us. We know that Jaylah Bass was laying closest to the wall, her head where this pooling of blood is seen, and that JJ's head was right next to her, either touching the mattress or slightly above, at the point in time that the firearm was pointed at their heads and the trigger was pulled. Remember last Friday when we discussed premeditation, Mr. Terry was talking to you about there's no specific time frame when you're trying to decide whether or not an act was premeditated. It can happen in an instant. Recall that today, Hillsborough County Sheriff's Office firearm expert Jennifer Michaelon took the stand and explained to you what would have to take place in order for that Glock 42 to fire. She explained you first have to take the magazine, you have to load it with bullets. You have to put that filled magazine inside the bottom well of the firearm. You then have to slide the top of the firearm back in order for it to fire. Then, like she explained, when she's firing these firearms regularly during the course of her investigations as a firearm expert, she uses 2 hands to be able to safely and precisely point and aim within a 6-inch area. Loading the magazine with bullets, putting the magazine inside of the firearm, sliding the top back to make it ready. And then she further explained, not only do you have to point it and aim it, each time you pull the trigger, you have to pull it hard enough to first compress the trigger pull, safety, and then the trigger itself. And she explained to you that because it is not an automatic firearm, that each time you pull the trigger, you have to pull it and let it go, and 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 pull it and let it go. And members of the jury, that evidence is the scene itself, the evidence revealing to you what premeditation is. All of those steps is the scene revealing to you through evidence what premeditation is. Look at the bullet holes. On these precious children's face. Look at them.
Objection, Your Honor, improper
Sustained.
argument. I
Look.
ask the jury to be disregarded.
Right. The jury's to disregard the last statement by the prosecutor. Let's talk about the facts.
Look where the bullet holes are located on Jaylah Bass's head. Those are aimed, precise, deliberate bullet holes. That is not an accident. That is not loading the firearm and it going off. Those are aimed, precise, deliberate shots. Shots that require some sort of control over the firearm. Shot through her cheek, her temple, and her forehead. Jennifer Michaelon says that shots that are within 6 inches of one another require her to use 2 hands to shoot. This is the shot on the son, JJ's head. Now, recall he's laying right next to his sister in bed, the top bunk. We don't know what order they were shot, but consider the proximity when deciding how deliberate these shots are. Consider the proximity when deciding how precise they are. That is the evidence revealing to you premeditation, intent and deliberate shots. Shots that are aimed at the most crucial part of a human being's body. Recall, the scene will reveal to you the evidence necessary for you to come to a conclusion as to what happened. We know from the defendant's wallet that was seized, states 15. Recall that this wallet was taken directly found in a closed drawer within a wallet that was right next to the firearm used to murder Jaylah and Jake, an attempt to murder JJ, and right next to ammunition found. Note on this, height, Jermaine Bass Jr. 5'7". Why is that important? Let's consider the trajectory of the fire's shot that killed Jaylah Bass and almost killed JJ. We know that the children were laying next to each other. We know that the blood shown in the pulling of this photo of the top mattress belongs to Jaylah Bass because of DNA. Consider the trajectory of the bullets you see. Knowing the bunk bed is, topmost portion of the bunk bed is 5 feet 5 inches tall. The defendant is taller than that. We know that damage A is at a downward trajectory, meaning that when the gun was fired, it has to be angled upward, downward to cause that downward trajectory. We know that this shot goes all the way through to the bathroom in a downward trajectory because we saw evidence of that. The scene will reveal the evidence necessary for you to decipher what happened. Whoever was holding the firearm had to have been taller than 5 feet 5 inches tall. We know that there was no stippling found on the wounds of Jaylah Bass, meaning that whoever fired the weapon pointing right at her had to be at least, from the testimony, at least 2 to 3 feet away from her. If you follow the trajectory of the bullet holes that you see here, take them out 2 to 3 feet. That takes you off the bed at a height consistent with the defendant holding his hand above the rail and pointing it downward. We know also that the person standing on the outside of this bunk bed, at least 2 to 3 feet away from where the children were laying, we know the trajectory as well because of the impact blood stain pattern. Now, Anna Cox, when she testified, was very educational when she was describing to you what blood stain pattern analysis is. She explained that it's a discipline of forensic science focusing on identifying, documenting, and analyzing blood stains in order to interpret what caused the distribution. Basically, in layman's terms, she says she looks at the blood stain and tries to decide how it got there. She went on to explain to us different kinds of blood stains and what they mean and how she interprets them. One of them was an impact blood stain, or an impact spatter pattern, which she said a natural object striking the liquid blood. She said she considered things such as physics, the natural laws of gravity, and introduction of a mechanism such as force. So if something were to hit an object bleeding, it would cause a certain pattern, a blood pattern stain. Directionality, flow pattern. She said in her expert opinion, based on the DNA evidence that was swabbed from this area, it showed that both JJ and Jaylah's heads were in this corner of the bed at the time in which they were shot. That's an important piece of evidence because, remember, we end where it began. When defense mentioned in her opening statement to you that their client didn't pull the trigger. Well, members of the jury, it's one thing to make a statement like that and then move on. But it requires you to pull the thread, to follow the analysis, to let the scene reveal to you what happened. And you have to follow it until the end. The end is the DNA on the firearm. Now, recall the series of events. The children are shot. They're on the top bunk. When law enforcement arrives, the defendant is holding his son, who's profusely bleeding from a gunshot wound to the head. When he's asked, "Where's the firearm?" he explains to the deputies that it's on top of a dresser, and later explains that it's in the drawer in the master bedroom of the dresser. So threat, because what does that mean? It means that after he murdered his daughter Jaylah, and after he shot his son in the temple, that he left them there, walked all the way past 2 bathrooms into the master bedroom, and he opened up that silver drawer. He put the gun and the magazine inside, and he closed that dresser drawer before doing anything else. That's significant. The gun was in a closed dresser drawer. If an accident happened in the room with his children, would not a reasonable parent render aid immediately?
Objection, Your Honor, improper argument.
Overruled.
It's not reasonable to believe that it was an accident. It's not reasonable to believe that after this firearm accidentally discharged 5 times, that someone would then walk past 2 bedrooms into a different room, open a drawer, place the firearm inside of that drawer, and close it before doing anything else. It is not reasonable to believe. We also know the defendant didn't call 911.
Objection, improper argument, Your Honor.
Sustained.
The phone records show that at 10:34, the defendant dialed out to a number belonging to his mother. Anna Cox was right. The scene reveals the evidence necessary for you to come to a conclusion as to what happened. The defendant loaded his firearm with a magazine. He slid it back to load it. He then stood on the outside of that gray bunk bed, put his arm up and over the railing, and fired at his children as they lay sleeping in the top bunk of the bed. The evidence reveals that he shot his daughter Jaylah 3 times, and she died. The evidence reveals that he shot his son JJ in the temple, causing severe injuries that he still suffers from. The DNA puts the firearm in his hands. The trajectory puts the firearm in his hands. And members of the jury, the evidence, when put together, forms an arrow pointing at the guilt of only one person in this case. The defendant, Jermaine Bass, murdered his daughter, Jaylah Bass, who was 5 years old. And he did it with intention, he did it with precision, and he did it with premeditation. The defendant tried to kill his son, JJ. And he did it with intention, he did it with precision, and he did it with premeditation.
Ms. Schlemmer?
Thank you, Your Honor. Please support.
Yes, ma'am.
Counsel. I was going to start talking about everything Mr. Terry talked about in opening statement and what he did or didn't show. But I want to first go ahead and respond to Ms. Reeder if I can. First of all, she said, these are things we know. These are things we know are true. She said that Mr. Bass left the children home alone in their beds. So they're in their beds and he leaves. There's no evidence of that. You didn't hear any evidence that they were in their beds when he left. He followed Shirley Bass. We have an hour later with his car, supposedly leaving, a Nissan Titan design, but he followed her. There's not one shred of evidence of that. To confront Shirley for going to a family dinner is why he supposedly stopped them along on the way onto 275 at the West Shore exit. You heard not one piece of evidence that he stopped the vehicle. And we're going to talk more about that later. But that it was to confront Shirley for going to the dinner? No, we didn't hear any evidence whatsoever about why or why not Mr. Bass did not go to the dinner. The children were laying down. We know that. Well, then why do we have bullet holes higher up? We don't know that. Ms. Reeder actually said, quote, read between the lines. Do you remember when she just said that in her argument? read between the lines. Let's forget about evidence. Let's forget about burden of proof. Let's throw it all out the window, folks. Just read between the lines and convict a person of murder. She went through this long, elongated theory, and I think it was done multiple times, that Mr. Bass got the gun. He put bullets in it. He put the magazine in. He racked it. He took it into the kid's room. What evidence did you hear about any of that? You heard not one piece of evidence of where that gun was prior to the shooting of the children. You heard nothing. We do not know. You don't read between the lines in a case such as this or in any case. There is absolutely no evidence that the state has presented where that gun was prior to the shooting, who loaded it, was the net. We know nothing. And they have to have evidence. Ms. Michelin told you that they didn't do a trigger pull. They could have done a trigger pull on that gun and given you a poundage of how much force. I think Ms. Bradley had asked her, it's about just 5 pounds. But what did she tell Ms. Bradley? The trigger pull on that gun is as easy as popping off a soda cap. Popping off a soda cap is enough force to pull the trigger on that gun. So the state wants you to believe that Mr. Bass did all these things. Well, because that's their theory, that's what they want you to believe. He got the gun, he racked it, he put the magazine in, he pulled the slide back, all of that. But you gotta look at the evidence, not their theory. Remember, the judge will tell you the evidence is where you look, the exhibits and the testimony, not one piece of evidence about that. Ms. Reeder talked about the wallet being found next to ammo. I guess to presume that that's an important factor. Not any ammo that could have been used in this case for certain, because there's not one thing found in the master bedroom that had anything to do with a .380. Detective Hobelman and Corporal DeVoe both told you that. How do I know? How do I know that Mr. Bass's driver's license type is even correct? Not one shred of evidence presented as to that. They want you to read between the lines and assume. Whoever is holding the firearm had to be taller than 5'5". We know that, said Ms. Reeder. Where did you hear that evidence? What witness said that? Nobody did. Theory, not evidence. And again, going through how he then afterwards goes into the master bedroom, does everything, puts the gun up, and closes the drawer, she said. Right? Evidence. That drawer's open, so that's not true. This is the way HCSO found it. That drawer is open. So what Ms. Reeder said there is not supported by the evidence. There is not one shred of evidence to support their theory and everything Ms. Reeder had just said to you. You've got to look at the evidence. You've got to look for the evidence. So let me go back then. In opening statement, Mr. Terry told you the following. Mr. Bass doesn't call 911. You will find out who he calls. Well, Shirley calls 911, or Mr. Evans actually calls 911 and gives the phone to Shirley. Shirley's calling 911. Why is there a reason for the spouse to call 911? You heard evidence, not theory, but evidence, that DeQuan and then Shirley, the call is made at 22:33, the 911 call. Mr. Bass does not call his mother until after that. Evidence, that's what you heard. Mr. Bass isn't calling Domino's to order a pizza. He's not calling for takeout. While Miss Bass is on the phone with 911, that is when Mr. Bass calls his mom to tell her what happened to her grandchildren. So we know from the timing that that call to the mother is definitely after the 22:33 911. Look at the phone records. It is 22:34, right after. We also know that it's a very quick call. 5 seconds may not have even been answered by his mom. All right, number 2. Mr. Terry says, Mr. Bass tells the police exactly where to find that gun. Presuming, I guess, he knows specifically because he's the one that pulled the trigger. Well, no, not quite. And Ms. Reeder even pointed this out in their argument. He's telling them that it's on the dresser. It's not until later that he says, look in or on the dresser. Ms. Reeder even told you that. And we have no evidence of where that gun was prior to the shooting. None at all. Ms. Reeder made a comment about Mr. Bass making the statements to the deputies that first responded. The statements are made mere minutes after the shooting. Well, the 911 call is at 22:33. The statements, she said herself in her closing, 22:46. That's 13 minutes. Marital discord. Mr. Terry said, oh, there's marital discord, and maybe that's why he did this tragic, horrible act. What evidence did you hear of marital discord? Absolutely none. Again, you have to look to the evidence, not their theory, because they have the burden of proof to prove beyond and to the exclusion of a reasonable doubt. You did not hear about any marital discord from China Gadsden, nor did you hear about any marital discord from Ms. Romeo. Mr. Terry said, you will never know why. He's correct, absolutely, when he says they do not have to prove motive. You will never know why. Well, we don't. And the problem is, there are so many unanswered questions over this tragic, terrible event that took place on August 29th of 2022. Many unresolved questions, mistakes made in this case by many different people. Too many unresolved or answered questions. Reasonable doubt. Mr. Bass didn't go to Ruth Chris because he was supposed to stay home to take care of the children. Mr. Terry said that. Where'd you hear that? Did you hear that evidence? Stayed home because he had to take care of the children. No evidence. Nada. There was no evidence presented of why he did not go to Ruth Chris that evening. Something is not right in that house. Okay? What evidence did you hear that there were any problems in the house? Nada. Mr. Terry then. Mr. Bass was angry and aggressive on West Shore and 275 when he came upon Miss Bass and Miss Gadsden. Well, no, that's not what we heard. We specifically did not hear from China Gadsden say he was angry. You didn't hear that. Nada. She claims he comes upon them, and all he says, were you drinking? Is that why she's driving? That's it. They're not arguing, they're not beefing, he's not yelling. Shirley wasn't fazed by it, China said. And that's it. And, folks, that's if you believe this story. Okay, we have China Gadsden, the one, she is related to Shirley. And one of the most critical things is, if this was a big deal, and this somehow is their great motive, theory, that's what they want you to believe to convict somebody of first-degree murder, why is it not talked about earlier? China Gadsden never says a word until over 14 months later that this allegedly took place. Corporal DeVoe even told you there would be times he would call China. She'd hang up on him. I don't want to talk to you. I'm not going to talk to you. All of the behavior of everybody in this case, Mr. Bass, Mrs. Bass, the witnesses, you can consider. And their behavior and everything that got done that evening. And China Gadsden never at any time said Shirley was upset. Now, I just want to make this comment. Do you honestly believe in Florida that they're sitting there, stopped in the middle of the road, and they're just sitting there, and Mr. Bass goes out, and he says, were you drinking? Because is that why she's driving? That's it, right? That there's a ton of cars backed up, and that one person is honking. This is Florida. Not one person is honking or blaring, saying, you guys need to go. That's what China told you. Ms. Bradley asked her, well, weren't the cars like honking if this story is true? Oh, no, it's fine. They were just waiting. Come on. It's just unbelievable. This was an act to kill, Mr. Terry said. Well, where's the evidence? Where's the evidence of premeditation, the intent to kill, reflection, enough time to reflect on that? Where is the evidence that the premeditation and intent to kill was in his mind before the act? We have no problems talked about, no issues, no evidence, none. No threats, nothing. Shirley was frantic on the 911 call, of course. She's frantic, she's upset. But you gotta look at her overall behavior in this case. You can look at all of that, and you should look at all of that. The 911 operator is constantly asking her, who did this? Who did this? Is the shooter still there? This is a mother. Supposedly, Mr. Bass has just shot and killed her daughter and shot her son. She refuses to answer that question. Never answers that question. At one point, Ms. Bradley talked about this in her opening, she specifically says, no, I don't need police, I need an ambulance. And of course, you'll have a call to listen to. We also have absolutely no clue who she's yelling at on that call. We know for a fact from the call, she's definitely yelling at the 911 operator for not getting there fast enough to bring the ambulance. We know, and she says it, how upset she is with the operator. Look at when the call comes back. She even says, I got the same person. I got you again. So we know she's upset with the operator. And listen to that call. Did you catch the comment about what Shirley said? Her son was supposed to be sleeping, but then he ran. What? Okay. Well, that just further shows me we do not know what happened in that house at the time of the shooting or what happened before. Listen to that call. You're going to hear her say that. And then he ran. Supposedly, as Ms. Reeder says, the children are shot in their beds. That makes absolutely no sense. Now, we know from Mr. Evans, Daquan Evans, that there was about 5 to 10 minutes span of time. That's what he testified to. Evidence. 5 to 10 minutes from the time he heard the shots to Shirley coming to his door, because she doesn't know the address where she lives, she doesn't have her phone. 5 to 10 minutes between the shots and Shirley coming to his door. What is going on in that 5 to 10 minutes? Ask yourself that. What is going on with Shirley, Mr. Bass, in those 5 to 10 minutes? We also know there's 2 parts of the call. There was no evidence presented by the states to show the time difference. In other words, was there 5 minutes between the calls? Was it 5 seconds? We don't know, because they didn't present that. And we certainly know, continuing in that second call, Shirley is still not happy with that operator. Take that in consideration as well as the first deputies at the scene. They're all equipped with body cam. Rahman, Rainey, White, and Jones. The big picture is what you can look at. Deputy Jones, I asked her repeatedly, who shot her son? He's asking a mother whose son has been shot in the head. Who shot your son? Is the person with the gun in the area, please? Never. His testimony, evidence, Shirley never answered him, never answered his questions. Deputy White, evidence. The woman was yelling at the officers. We were just trying to help. Deputy White, Shirley was uncooperative in providing any answers. Evidence. Now, the state, I anticipate Mr. Terry's going to get an opportunity to come up and talk to you when I'm done. Please keep in mind what he says and think what I might say in rebuttal to that, and keep in mind he has the burden of proof. But I anticipate, since this is my only time to talk to you, he's going to say, well, she was traumatized, right? She's traumatized. So you got to look at that whole big picture about her uncooperativeness, and we'll talk more about that. But it doesn't explain this case and not answering simple questions posed to her by a 911 operator or the deputies. Who shot your son? My husband. Never, nada, never says that. Deputy Jones, the lady wasn't very helpful. That's it. Not helpful at all. Now, Mr. Bass, another comment from opening statement by Mr. Terry. Mr. Bass never tells the police his daughter is upstairs. Not true. Evidence. You heard from Deputy White. Body cams, you've got beeping going on, they're difficult to hear. Deputy White said that Mr. Bass did say something about a little girl, and he documented it in his report. It wasn't just off his body cam, he told you that. I heard that. What you kind of hear on the body cam is something like, anyone upstairs? No. Then you can hear something. Watch those body cams again. Something is said right after that. And I believe that Deputy Rainey's body cam may be one of the best to pick it all up. But listen for the word daughter. Then, is anyone else in the house? No. But I didn't make that up. Deputy White took that witness stand under oath and said he did say something about his little girl. But Mr. Bass is not allowed to be traumatized. Well, Shirley Bass is. You can't have your cake and eat it too. Now, Deputy Jones even told you, well, I didn't hear that. I didn't document it in my report that he said no, but I was walking behind Deputy White. And I just walked quickly past Mr. Bass. And he specifically told you he might have heard something, Deputy White, that Deputy Jones did not. Evidence, that was his testimony, because Deputy Jones was behind Deputy White. Evidence, he told you that. So I ask that you watch those body cams again. I'm sure Mr. Terry will say the same thing. Now, let's continue on concerning Shirley Bass. Her daughter was killed in a tragic event. Her son was shot in the head. But she desires to be uncooperative with Detective Gabot. He asked for her phone. Remember, her phone was in the crime scene. Some member of HDSO went into the crime scene, took her phone out, and gives it to her. So she has her phone back. Mr. Bass's phone, able to be downloaded, is on the couch. You can see it, right? He's asking, I want to download the phone. No. Never does she give her phone to him to do a simple download. And guess what, folks? You saw phone evidence, right? Now, I believe it was Corporal Gabot said there wasn't anything on Mr. Bass's actual download, but that's why they look at it. That's why they do a cell write. Because it does reveal evidence, and it is important. She was hard to reach, he told you. This is a woman whose daughter was killed and son was shot in the head. Mary Lee House. You heard about Mary Lee House. It's kid-friendly. There's just the interviewer that works at Mary Lee House who's trained to speak to children in a kid-friendly environment. They have to do, and they want to do, an interview of JJ based on what happened, what he saw, what he did. On 9/7 of 2022 in the AM, Shirley absolutely refused to let her son be interviewed. Now, the state's going to say, oh, Corporal Gabot said he was just out of the hospital. Well, then say that. Can we wait a little bit? No. She lies to Corporal Gabot. You heard that. And said, well, I got here earlier, and I waited a long time. Remember he told you that? What else did he tell you? That's not true. Because I was here early, and she was not here. So we know that's false. And Corporal Gabot, what other interesting thing did you hear about that first attempt to interview JJ? Oh, I never even saw the son. He doesn't know if she even brought him that day. So he says, okay. Let's reset it for the afternoon. Same day, September 7th of 2022, for the PM. Now, at this point, JJ's uncooperative. We didn't hear testimony that he was in pain or he was upset. Look what had just happened to his sister. We don't hear that. What do we hear? And I hate to even talk about JJ like this. I'm just going to tell you the evidence, please. Corporal Gabot tells you the interview did not take place, that second attempt, because he was disrespectful, had bad behavior, and was actually physically attacking Shirley. Then we have another attempt. Well, let's try to do it on 9/12 of 22. It's now reset for the third time. That interview didn't take place. We know at that point, Detective Brunel and Detective O'Toole have to go get an investigative subpoena. Corporal Gabot told you all about that. It isn't an invitation, Corporal told you. It was served on her on September 23rd of 2022. So finally, I think this is the fourth attempt at this point. You know, not Shirley, just give me some time. No. Excuses, excuses, excuses. Finally now, only over a threat of being arrested if she doesn't bring JJ in does the interview take place. This behavior is not consistent with a woman whose husband just in cold blood, premeditated, shot his daughter, Shirley's daughter, 3 times and shot her son in the head. It just makes absolutely no sense. Corporal Gabot told you she was uncooperative with the investigation. Something she was cooperative with, he told you. He didn't quite tell you what those things were, but she was uncooperative. Just the same as you've heard from every single deputy that took that stand, the first responders. He also said, quote, Shirley was uncooperative with all attempts to have her son interviewed. What is going on here? What exactly happened in that home? What is going on? Do you really know, beyond and to the exclusion of all reasonable doubt, what happened in that apartment, that townhouse, for that gun to be shot and the children to be injured? Mr. Terry, in opening, Shirley was very frantic. He also seems to imply in his opening, but Mr. Bass wasn't, right? Shirley is frantic on the body cams. We see her. But nobody has met Shirley before and doesn't know how she acts. Nobody has met Mr. Bass before and see how he acts. Not Mr. Evans, not the deputies. We talked in Bordier, if you remember this. Do people act differently to trauma? You guys agreed, yes, you can. No two people are alike. You can be frantic, or you can be like a blank slate and in shock. It sounds like Mr. Bass and Shirley as well. So people react differently to traumatic events. And certainly being, quote, blank and quiet, the words of Mr. Evans to describe Shirley Bass describes Mr. Bass. In addition, you can consider what everyone else told you from the Sheriff's Department concerning Mr. Bass. Unlike Shirley Bass, he was cooperative with the investigation in all stages. Now, we also know that we hear Mr. Bass tells the deputies, come in, come in. You can literally see, watch the body cam, he's all sweaty. You can see the shine because he's sweat from trauma. Just help my child, please. I believe Ms. Reeder just said in her closing that he never asks for help or to help his children. Absolutely false. Just help my child, please, please get the paramedics. Again, evidence from the body cams. Mr. Terry, in his opening, Mr. Bass said it was an accident. This was no accident. Did y'all notice that when Mr. Bass is first asked by the deputies how this happened, what does he say? He says accidental discharge. That's what he says to them first. He doesn't say, I did it, I shot it. He says accidental discharge. It's a period of time. Deputy Rainey steps outside. He notifies that they have found Jaylah. And then the house is clear. Comes back in the house. They're frantically taking care of the children. Fire rescue is coming in. Later, when Deputy Rainey is asking more specific questions, then, and only then, does Mr. Bass says, it was me, I was cleaning the gun. Common sense dictates. No one's going to be cleaning a gun in a kid's room. What is going on in that house? What happened in that house that tragic evening? We don't know. You didn't see any cleaning supplies out, did you? I submit to you, he was not in the kid's room cleaning the gun. He was protecting someone else. It just makes absolutely no sense. And evidence that you have is that we do know that there was a substantial period of time, 5 to 10 minutes between the shots and Shirley coming to ask to use Mr. Evans' phone. Why she's even doing that, I don't know, because her phone is in the townhouse where it's retrieved by one of the members and given back to her. And we know there's a gap in the calls. What did Mr. and Mrs. Bass discuss in that time period? Is Mr. Bass protecting someone? We don't know.
And that is aggravated child abuse. Both counts. It's not only premeditated murder, it's felony murder, because he is guilty of aggravated child abuse for what he did to those children, and that makes it felony murder. And I'm convinced, ladies and gentlemen, that when you go back there, use your common sense. Think about what is the evidence to best rely on. The state has no doubt that you will return a verdict for guilty as charged on all 4 counts. Thank you for your time.
Thank you. All right, so it is almost 6 o'clock. My intention, unless you would like to vote to overrule me, is to go ahead and release you for the night, to come back tomorrow and begin your deliberations fresh tomorrow. If you would like to overrule me, I see a bunch of you nodding already, and would like to